I didn't make a mention about it. And carelessly of the year 2004, cognizance has been taken Why do you feel that it will not be heard today? In the morning, at least in the morning hour, you will be positive that you will hear all the matters. But I think 75, 100 16 matters. We have matters of 2016. Yes, 2016. 75, number 6. Sorry? Come in the February. Can say it will be stayed and I think it will be the petition and the paper of the principal of the committee. Which matter? Yeah, yes. Why don't you give a copy of the application so that you will understand? Behind is that you want to tell. We are no, I do not know. Please give a copy so that at least by the time the letter reads to me understand what you are doing. Just see possible, we will see otherwise. Okay. Just see what if it is not a very serious matter, then we can just go through. I don't think you can tell me. Yes, what? Yesterday I received copy. So always come 2 weeks after. In the meantime, I'll try counter. Here, what I the counter as well. I don't know, but the date is fixed there to the 4th of December. I think I have said that you move application. That was not no, that because date was not fixed. 4th December, no, 3rd December I will hear. 3rd December. It's not 4th December. Next week, 3rd December, how many? 3rd December, by the time you file it, 3rd December. So it will be 2nd December. Yeah, Monday will be that weekly channel is every aspect. So therefore, that is the reason I say Tuesday. If you want Monday, no problem. I'll be comfortable. Second. I need to submit to withdraw the balance. I will even deduct it. Next matter. Anything good? Yes. Maybe. Yes. Recalling of witnesses, my lord. 1 minute. I have recalling. Yes. 1, 2, 3, 4. Here is the case manner where traffic was committed 1%, 148, 323, 294, 453 to 506, 354. Where are the I have given the question as on the when the people were examined. My lord, 18. Then from both sides. On recording the I'm replacing the mind of command. Yes. You are directed to solve the problem. And you consider one of the out of story which witness you want? Not only four of them. I give opportunity for one. In 2018, we have examined these people. And thereafter, you kept quiet. And move application in 2024 and see the reason. And that the defense counsel has not elaborately cross-examined so and so, and vital question were left. What is the what is the reason of not? My lord, here, my lord, 22 persons have been charge sheeted, my lord. And but see your application. What is the reason? Why have you not cross-examined? Is it a case that the opportunity was not given? You say opportunity is given. Yes, my lord. But I did not do it. Recall is not the fill of the gap. So you came out of the slander and asking for recalling. Yes, here is the, my lord. In this case, my lord, it's a case and counter case, my lord. Whatever. Counter case in compromise. What are the offences? What are the offences? My lord, offences are, my lord, CSP along with other offences. Okay, you tell me which witness is the vital for you? PW 4. 1, 2, 3, 4. You choose one. 4. Okay. 2. I'll allow 4. Yes. For one opportunity, and your lordship also told them input court because one opportunity for one witness. Whatever you want to do. Right. Petitioner is agreed by the order dated 18/1/2024, whereby his application under section 311 CRPC for recalling the witnesses, namely PW 1, 2, 3, and 4, has been rejected. The petitioner in his application inter alia stated that stated age under para 9, page 9, para 2 and 3. The content of the application is not disclosing the reason for not cross-examining the witnesses, those who have been summoned by the prosecution way back in 2018. The petitioner has only contended that vital questions could not be put to the witnesses. However, no reason is coming forth as to why such questions were not put to the witnesses when they were examined. To confront with this situation, the counsel for the petitioner submits that he would not insist for recalling of PW 1, 2, and 3. Rather, PW 4 being a vital witness may be recalled, and one opportunity may be afforded to him. I see force in the submission made by the petitioner, and therefore the imprint order is set aside to the extent that the recalling of all the 4 witnesses are to the extent that the recalling of witness PW4 is necessary, and accordingly the trial court is directed to afford an opportunity to cross-examine the PW4 on a particular date to be fixed by the trial court before the petitioner is afforded the opportunity to cross-examine the same witness, that is PW4. The proposed question enumerated in the application under 311 CRPC moved by the petitioner shall be the relevancy of the question is enumerated in the application shall be tested by the trial court. It is made clear that the petitioner shall not seek adjournment on the date to be fixed by the trial court for cross-examining the PW4. With this observation, petition is dismissed. Yes. Next.
Item 2, sorry to make a mention, my lord. This is very urgent matter, my lord, because the code number 22 is not functioning.
I have started the board.
Sorry.
Okay, you say, since you have started, what to do now? Yes, yes.
This is my 25th examination, my lord. The petitioner is actually pursuing his master's in mass communication. It's an interim bail application, my lord.
Bail application.
Interim bail application.
Why is it in this court?
Section, the code number 22 is not functioning. So notice is there, that will come before your lordships.
When the examination?
25th, my lord.
25th?
Monday.
Monday. So then tomorrow we can move.
Saturday, Sunday, my lord, there is a holiday, so difficult to furnish the bail bond, my lord.
Tomorrow we can do it. What is the issue? Tomorrow we can do it.
Tomorrow also the code is not there functioning, my lord, 22.
I don't know. Anyway, his career is involved. Why unnecessary?
After launch, my lord,
You just give a copy to him.
yes, ma'am.
I'll give it a copy to him. By 10 o'clock tomorrow, first item I'll take.
After launch possible, my lord.
No, it's 120 minutes. Tomorrow, and give the copy to him. He'll seek instruction.
Yes,
Just verify it.
yes.
So the verification will also be done tomorrow at the first item.
Launch.
Then it will go to that court. If he doesn't sit, then and seek instruction.
Right.
Huh? Seek instruction. Give the copy of the petition. Extra.
Yes, yes, right now also.
Yes. Problem. Tomorrow is first item. Yes.
Item 2.
Maybe my lord, kindly see last order, order 2524, my lord.
Sorry.
Kindly see last order, my lord.
Last
Order
order.
2524, my lord.
Your lawsuit is directed to
Instruction.
Instruction, my lord.
whether why then the bank account has been treatment. So that instruction not found.
The persons to the order dated 2/5/2024. No instruction has been received by the state council, hence he seeks an adjournment. Leaves the matter after 1 week. Yes.
Item 3. He has filed a mode.
Just for a review.
Which case for?
The complaint. I
You have not implemented.
No, but the last time the court directed for to implement the.
Yes. Have you done it or not? Acha, miss case. Okay. IN number?
814 out of it, I got in the IN
814. Huh?
1152.
For the reason stated in the application, the same is allowed. Petitioner is permitted to implement the informant as opposite party number 2. Amended memo practice to be filed within 2 days. Within 2 days. What is the case is about? Notice has required to be issued, I think. So, issue notice to the newly implicated opposite party number 2, returnable after 2 weeks. Yes. Next.
But that case has been that someone has been issued in the.
What can I do? You file an incomplete petition. And now today the only IA for allowing implement is there. I am allowing an issue notice also. Beyond that I can't do. If you file this kind of petition, what to do?
Yes, ma'am.
Yes.
379 386 Act, my lord. The parties has come. They are in the queue, my lord, to get the pass, my lord.
Okay.
Just pass.
Yes. What are the offenses?
379, 320, all are, my lord. So far, the petition.
Let's see whether there is any legal bar.
My lord, no. 386 is the highest offense so far, sessions tribal constable, and 379 and 323, 294.
SCST.
Yes.
SCST. Charge sheet is in file.
No, my lord.
Not filed.
Investigation.
Anyway, just check it up. Huh?
My lord.
2 o'clock. Yes.
Before, can it be before that? Before
12 o'clock. 12 o'clock.
Before rising?
12 o'clock. Yes, 12 o'clock. Sorry?
Okay. So, back to
Just check it up.
6. May I please, Lord? for an application for interim release of the vehicle which was allowed by the district judge since 31st/10/2023. It is about 1 year, in November 2024. I have complied with the conditions. And the conditions to the harsh security deposit. Thereafter, the video recording, all that. I have filed one CRLMP position report that the order of the district judge has not been complied, relying on the decision of Ashish Ranjan Mahanti's case and also Arun Kumar Agarwal's case, your lordship know. Like that factored in one case, your lordship judgment. My case is covered by that judgment.
Where is the first order by the passed by the trial court?
Passed by the trial court. Trial court first order was submitted before the district judge. Trial court rejected. But still the confiscation proceeding is pending.
That's right. Thereafter you filed a revision petition.
I filed a revision for the district judge. District judge revision allowed.
I understand. Where is that order of trial court? I am asking.
Filed for the
Which where is that?
this court after your lordship input that order I have filed.
Where is that order, sir?
The rejection order was filed before the district judge. Then district judge set aside. Your lordship kindly.
Sir, where is that order by which your application by the trial court rejected your application under 457? Where is that order I am asking? Against that you went to the revisional court.
Yes.
Revisional court has passed some order.
Yes.
Okay. That order you have filed. Where is the main order?
Trial court rejected. I have challenged the rejection of the district judge. District judge set aside the order and allowed.
I understand, sir. As much I understand. Where is that first order?
That first order I have filed for this honorable court.
Where is that? It's not there. Therefore, I am asking. In the file, it is not there.
My file also there is not there.
You have not filed it. Check it up.
My short date. I will inquire. I filed.
Last time also you short time. Why are you filing incomplete petition? I don't know. See, 4 days has gone unnecessary.
Yes, that order I filed. I inquired.
You see your petition. You show me. From your petition, show me.
My petition.
Yes. Show me which page. I'll search it up from here if you have filed. Just.
Already pass over.
Yes. You have not filed it.
I
sure?
before this court, you lost.
Okay. Well, if you filed, it's found out. If it is there,
I got the certificate copy again.
I'll just.
File here.
Certificate copy is not required. Only give me copy. Let me understand what is the order
Yes,
inside.
yes. Just pass it.
Yes, password. No problem. Yes.
Item 7,
That's why item 7 print for password.
Password.
item 8.
Yes.
This is the another 6 automated 848
Yes.
rejection of the plan petition by the Lord James Bourbon son-in-law. Case involving 1cc case arising out of a 138 proceeding.
You are the accused.
Yes, my lord. My petition has been rejected on the ground without mentioning any reason. Regular 50 level petition has been allowed. Thereafter, it was posted for recording the witness. The witness is not present. I have remained for 4 days, 4 dates. Thereafter, he didn't come. I seek for time. My application will be rejected without a
Where is that application?
It's page 48, my lord.
40?
48, last order.
48.
24. Page 48. Annexure 6, page 48. 46 is the 311 petition. Thereafter, at page 48, rejection of my time petition.
Yes. Why you see this, your 311 application was allowed in September
Yes.
2023.
How?
You have been taking time to,
Yes, not, I have not taken any time. Last time I have taken the day petition was allowed, thereafter I was very well present, and last date on 6/4 I was seeking on the ground of illness, my illness.
see when the complaint was filed when? The complaint was filed in 2020,
Yes, no,
4 years, 138 NI.
that was not my fault, my lord.
I don't know whose fault it is. Right? I'll just allow it. Hey, 311, see, this is nothing. See, 311 application, his application was allowed to re-examine one of the witnesses. Okay, that is on 27/9/2023. Thereafter, what had happened is the witness have come and the complainant.
Private party chief.
Anyway, the complainant has taken twice time. And third time, when the matter came up for cross-examination, he sought time, which was rejected. Unnecessary. Petitioner is agreed by the order dated.
No, thereafter the subsequently NBW has been issued for the appearance, my lord. That is on 4/5.
Don't multiply your problem.
Yes.
First of all, you don't go.
Oh, okay.
Opportunity is given. Thereafter, you
Sorry.
don't attend the court also.
Sorry.
Better, I'll set aside it
Yes.
and give one opportunity to you. Take the witness, whatever, whichever witness you want to take and do it. Finish it up. Right. He is the last witness or some other witnesses are there?
No, he's the complainant, he's the last.
Last witness. Okay. Right. Petitioner is agreed by the order dated 6/4/2024, whereby his application for seeking adjournment has been rejected and the cross-examination for the complainant,
Yes.
complainant being witnesses, being the witness is declined. Petitioner is facing trial for offence under section 138 NIA initiated by the opposite party. On 27/9/2023, petitioner moved an application and the petitioner's application under section 311 CRPC to recall the complainant for further examination was allowed by the court below. When the matter was taken up subsequently on 29/11/2023, the complainant counsel sought the petitioner sought time which was allowed. Again, the matter was listed on 6/1/2024. On that day, the complainant sought adjournment. Subsequently, on 25/1/2024 and on 29/2/2024, the adjournment was sought by both the petitioner oblique accused and the complainant oblique opposite party. Eventually, the matter was fixed on 6/4/2024. On that day, the petitioner oblique the accused has sought for an adjournment before the trial court, which was rejected, and the right to cross-examine the complainant is declined. The petitioner is agreed by the same. Regarding regarding head to the fact that the complainant and the petitioner jointly had been taking time, and an application under section 311 CRPC had already been allowed by the trial court. I am of the considered view that the petitioner is entitled to a singular opportunity for cross-examining the complainant who has been recalled for further examination by the order dated 27/9/2023. Accordingly, the present petition is allowed, and the petitioner is directed to appear before the court. By on or before 30th of November, and November. The trial court is directed to fix a particular date for the cross-examination of the complainant. On that day, the petitioner must conclude the cross-examination without seeking any adjournment.
May I ask one small thing?
Yes.
The accused petitioner is from Delhi. Not a little more time maybe preferred.
Online let him appear. Now everything is online. You do it, whatever. Because 2020, this matter is going on.
Okay.
I suppose I'll issue notice, it will take another 2-3 months. So therefore,
I got the copy.
pass over at 2 o'clock. Yes. Next. Yes. 9. Yes.
But 363 cognizance has been taken. And he is in Para is stated that by virtue of the settlement between the parties amicably, the petitioner and occupant two are living separately and maintaining their his life peacefully. 20 years of period of 15 years get on.
Investigation is going on.
Sorry, it's 363 with acid cognizance.
Only 363. No punction and all.
No.
Let us pass over. Let us. Yes.
Your Lordship, the
Yes.
matter arises primarily out of an FIR that has been filed against us by the informant. Since he was the informant, so we thought that first, if your Lordship hears us, admits the matter and issues notice, then only we will serve a copy upon the informant.
No. What is his matter?
His matter is.
Yes.
My lord, the case is, background of the case, I am the landlord, they are the tenant. They did not, in spite of several notice, they have not evicted the premises. However, they have
cases.
a FIR was lodged against me. So I am not in a position to go to foreign country because passport, everything is.
You are the landlord.
Yes. And I have the
1 minute. Have you initiated any proceeding for eviction?
yes.
What is happening?
This case pending in the before the civil judge senior division. Who was that?
3 years, your Lordship.
Yes, and
You are the tenant. You are not the
my lord, I have taken over possession. Subject open court require like
he has vacated. My client has vacated already.
many allegations they are alleging against me. Gunda lagegi, karidele, tala pakedele. These are the
Why don't you settle it?
yes.
Why don't you settle it? Unnecessary. Why?
I'm going to pressing fee. Do I tag again?
See, at the end of the day, forget about everything. End of the day, you are the tenant. He is the landlord. You can't be owner. Once tenant is always a tenant. Okay? You have evicted. You have been evicted by you thrown out, whatever. So some misunderstanding has taken place. Why don't you settle the issue?
Bow down.
I'm sending to mediation.
One thing, your Lordship.
Government says that that will be better.
No ego issue here. What is your grievance?
Invested so much money. For
Those things will be decided.
If you are tenant, everybody, all of us have the same experience. If you when a tenanted premises, you will spend money for your comfort, and eventually you're evicted, then you have to,
But your
you
Lordship,
have to please.
Your Lordship, I'm requesting your Lordship to kindly consider our situation.
What do you want? You want some compensation from him?
Yes, if he can actually pay back.
You can work it out. If he's generous enough, he can give something. Have you paid the rent, full rent? There must be some areas.
He deducted our rent. We had given 30 lakhs of security amount, which.
So it is end of the day, it is some money dealing between both of you.
I will get my lord, I will show the documents. I will get money from them.
So all these things you settle through mediation.
My lord, I will be reasonable. Yes. Wow.
Just if your Lordship kindly gives me some time.
I will stay the proceeding, both the proceeding. I am sending you to mediation. Yes. Later come. Both the proceedings also.
Both the proceedings.
No. Otherwise I'll dismiss it. If you want to show arrogant about fighting out the case, landlord tenant dispute unnecessary, filing cases, cross cases and all, why don't you sort it out? I'm sending it to mediation, I'll stay the proceeding. And work it out. It doesn't happen, then I'll come back, we'll see.
Yes.
But it will definitely happen. Definitely happen if you try. Okay. That in both the cases. Petition, first case law. The petitioner is seeking, what are you seeking here? Quashing.
First case, we are for the informant, Your Lordship.
You are the informant.
Yes, sir.
Acha. What are you asking that in the first case?
In the first case, we said that we had invested, we entered into an agreement, they did not, they deducted money, they had.
What is the offense?
The offense is of 420, 406, 454 and 506. Your Lordship.
So what do you want in this proceeding?
Your Lordship,
Quashing.
we wanted, no, Your Lordship, we just wanted our money back if we.
Recovery in 482.
Yes, sir.
What are you exactly wanting in this petition? You are the informant.
Yes, Your Lordship.
What is the prayer?
We just want the petition should not be quashed because we have actually.
This kind of jurisdictions are also there in you that you will move in preemptory applications that don't quash it. I can understand, quash it I can understand. Can you move an application saying that don't quash it?
So it's already stayed there.
No. No.
That would not be justice.
Both cases is there. No, first case is case.
It is to stay. Is your first case.
Both the cases go to mediation, right?
Yes.
Both the cases jointly pass an order, both the cases. The dispute in both the cases, the dispute is between the landlord and tenant. The petitioner in CRLMC 2146 of 2024 was the tenant under the petitioner open number 2 under the open number 2 on the open number 2. There is allegation and counter allegations. It appears that the tenant has already evicted from the premises. The allegation against the tenant is that he had spent used money in the premises, which has been premises, and between the existence of the agreement, he has been thrown out forcefully, and there are counter allegations made by the landlord. Be that as it may, the fact remains that the dispute is between a landlord and tenant. Yes, claims and counterclaims.
I will also get money from them.
Claims and counterclaims.
Yes.
Therefore, it would be expedient if the parties are referred to mediation center, the High Court Mediation Center, for exploring a possibility of settlement. Hence, both the matters are referred to High Court Mediation Center. The coordinator of Mediation Center is directed to fix a particular date and inform the same to the parties awaiting the mediation report. Proceeding in both the cases. Proceeding one proceeding or two proceeding? Two proceeding. Give the particulars of the proceeding, which court and all. Both the proceedings. Proceeding the further proceeding in the following cases are stayed till the mediation process is going on. However, right and give, they will commit some mistake. So explore the possibility, give some money, take some money, whatever.
One thing can I say, my lord? I have filed a miscase interim application 1944, but that is for release of my passport, my lord.
You do one thing, I'm giving a short notice after 2 weeks. It doesn't happen, come and I will release it. I will release it.
Central government will be fine. Yes.
So therefore you do it, doesn't happen.
Due to criminal case.
No, it must be seized by the police.
Yes,
You have to release it.
seized by police. Otherwise,
I think you can settle the dispute and everything will come to it.
my lord may indicate that passport.
I will hear it and go and do it. Doesn't happen, then come. Mention it. Okay.
Case is pending, my lord.
Yes. I'm just awaiting the mediation report. I have picked it up.
My lord, obliged.
Go ahead.
Yes.
Item 12. May it please your lordship. May I please? I am in virtual mode.
Yes,
Lordship, I am for the petitioners,
yes.
and it's a way back case of 2014, and subsequently both have the issue was being subsided, and they are presently residing. It's a compromise case. But Lordship, today they couldn't attend the case, so the time may be fixed the next week so that they can appear.
Why don't you bring them?
Lordship,
10 of them. Writing and all.
436 is coming. 436 units.
Please tell them, is there any legal impediment? I'm just adjourning it after 2 weeks. 2 weeks. If there is legal impediment, you must tell. Okay. Yes.
40.
Yes. Somebody mentioned it. Hmm? Probal किधर?
The copy solve करेगा.
You ask guy, he's not done. Yes.
40.
14.
There is the main prayer petition also. Why 6 OPID Act is not been added in the charge, the cognition also.
Who is he?
The present persons are the investor in the invested money in the society also.
Investigation is going on. He filed. Charge sheet filed.
He also charged. First time it come also.
Just check it up.
Yes,
No.
that is the file.
Yes. Charge has been filed.
Yes, sir. And some of the witnesses have been examined in this case also.
What at this stage? Who? Pass it over, Ulchi.
Yes, sir.
Right.
15.
15 and 16 I will pass over my God.
Pass over.
17.
Yes, 17.
It's also is seeking for quashment of the entire criminal proceeding, Your Lordship, and order of the cognizance under Annex 4.
Order of cognizance.
Yes, Your Lordship. 4/2021. That is page 14, Your Lordship. 14. Page Annex 2, page 14.
Item
17.
17.
Sorry, Your Lordship. Sorry, Your Lordship. 17 also quashing.
Investigation must be going on.
Yes, Your Lordship. 24, Your Lordship. 24, 7/24 is the date of affair, Your Lordship.
Investigation must be going on.
Yes, Your Lordship.
The petitioner is seeking quashing of the non-appeals for petitioner. Petitioner is seeking quashing of the FIR. Jajpur PS, Bari PS case number 114 of 2024, registered on 7/3/2024. It appears the investigation in the present case is still going on. At this stage, the petitioner has filed the present petition seeking quashing of the FIR. Quashing of the FIR. Since investigation is going on, I am not inclined to entertain this petition. Entertain this petition. Accordingly, the petition is disposed. Yes.
18, my lord, I am appearing through VC, my lord. My lord, I seek for an adjournment because somehow the file is
18.
18, my lord. File is misplaced, my lord. I seek for an adjournment.
Adjournment.
My lord, because the file is misplaced, I couldn't find today. So, my lord, kindly accommodate, my
Yes.
lord, next week.
Adjournment. Yes. 17 is disposed of.
Let's my instructions, charge sheet has been filed and 3 of the petitioners in the present petition, they have
then,
not named in the charge sheet.
At this stage, counsel for the petitioner
Look,
submit that
maybe-
charge sheet in the present case.
Kindly give a date, will also get the charge sheet.
Liberty is granted to the petitioner to
I'll get the charge sheet. in the-
renew the prayer if cause of action subsists. Yes.
Let's all get the charge sheet in the lab.
What is this? Just see the one line petition and an FIR.
There's a
Cross it.
case and counter.
Whatever, see the petition.
Been drafted by,
Don't reduce the standard up to the High Court to this level. Please,
drafted by, and I am appearing.
whoever may be. This is High Court. Thank you very much that you have not sent a check to me. What's it? There's something we should write. And one FIR, and annex and quash it.
Let me grant me liberty.
I have given a liberty.
I'll have this application.
You file it. I have disposed it up with liberty to file a better one.
19.
Please don't file this kind of petition.
I understand, Milot. I understand Milot's clarification.
And henceforth I'll impose cost when this kind of petition comes. Every cost, I'll tell you, I'll sometime impose cost of 50,000 rupees.
Okay, read the petition.
Can't do it in the High Court.
I apologize, Milot. When I read the petition also, I realized it has been drafted in
What is this?
casual manner.
Yes, next.
19.
Belgium matter
Yes,
that NBW was issued on 19/10/2023.
yes.
I have annexed the order. And my lord petitioner was on bail by order dated 4/11/2019.
Okay. NVW 23, 500. Yes, 500. Yes.
20.
It's a petition to honor of the vehicle and she did. It is not named the affair. She filed the document, she can't come. I am filing again. So,
What do you want?
The case is involved in the vehicle is involved in the NDPS Act, your lordship. Seeking for release, your lordship, that the impugned order is annexure 1, your lordship, page 12, starts from 12. The relevant page is, your lordship, the 17, your lordship.
17.
Yes, yes.
Yes.
Here, what happened, the vehicle has
What is
transported
this? What is this? You find?
38
Huh?
kilos.
So file it in the registry.
it's not already gone, it's not already killed.
It hasn't come. Okay, next. Next.
21.
Adjourn to February.
Receipt, update receipt.
February. You can't file this kind of petition and unnecessary.
Register receipt. It will come.
Let's see what kind of petition you filed. Will you insist? If you insist, I'll impose cost. Better that you should be happy that I have adjourned the matter. Otherwise, dismiss the matter.
May I please your lordship?
Yes.
Petition for quashing out of the criminal proceeding.
Hmm?
And
Not this one.
Other but 5,000 or something impose the cost already. Yes, I know. Yes.
my lord, I am the accused number 2.
Accused number 2.
My lord,
Yes.
I have a glance at page number 16, that is the FIR. The FIR speaks.
You want quashing of the.
Yes.
Okay. Come to the charge sheet. What are the allegations? Let us see. Vijay Kumar Rao.
There is nothing against me, my lord. There is no material.
Yes.
Improvement added as OP2, your lordship. The notice may kindly be issued to the OP2.
No, let us see. Come up with a case is there.
Yes, page 20.
Notice is not routine.
The 25, in the brief, your lordship.
If the allegations are there, why notice? Yes.
Can glance, page 25 in the brief, your lordship. Brief
Yes.
the case, your lordship.
Yes.
One present prisoner to his range holder, namely Subhas. The complainant before Subhas.
What is the name of this petitioner?
Vijay Kumar Rao.
Vijay Kumar. Yes.
Came with Vijay. Your lordship, can glance on the father house from.
She came with one Vijay Kumar to his rank.
Thereafter, on 21/21 at 12:30 PM, she came with one Vijay to his range holder, namely Subhas. The complainant before the Subhas, she scolded her and scrubbed his face and took his mobile. Sangeeta then threatened to him to murder by petrol.
And in the entire charge sheet, your name is only there. Who else?
Vijay Kumar, the present.
Sangeeta is accused number 1 and everything is against Sangeeta, not against me.
Let's see, read it. Read it.
That's why my lord, I will answer page number 16 the FIR.
Forget about FIR. After FIR, investigation has taken place. These are the things which came against you. Read it and tell me if any case is made out, not made out.
My lord, that's why have a look on.
Forget about FIR. Read
In the FIR, it is specific.
FIR is not everything.
I have not.
Why don't you understand? After FIR, investigation has taken place. Now charge sheet has been filed. In the charge sheet, there are specific allegations against you.
I have not slapped. I have not threatened him.
Then I will have to call that lady to whom you slapped to ask whether you were slapped or not.
My lord,
If she no, then I'll cross it. I'll take a and you cross examine also here in
the statements of the witnesses. At page number 27. That is the eyewitness. What is the informant speaks? That ମୋର ନାମ ସୁବାସ ଚନ୍ଦ୍ର ସୂତାର ଅଟେ। ଆଜି ତା 24/10/21 ତାରିଖରେ ଉପରୋକ୍ତ ମକଦ୍ଦମାର ତଦନ୍ତ ସମୟରେ ଏହି ବୟାନ ଦେଉଅଛି କି ଗତ 21/10/21 ତାରିଖରେ ଦିନ ପ୍ରାୟ 2:30 ସମୟରେ ସୁଶ୍ରୀ ସଙ୍ଗୀତା ଦାସ ଯେ କି ଦେବେନ୍ଦ୍ର ଦାସର ସ୍ତ୍ରୀ ଅଟନ୍ତି ଓ ଅଲଗା ରହନ୍ତି ଜଣେ ଲୋକ ଯାହାର ନାମ ବିଜୟ ଆସି ମତେ ଘର ଭଡ଼ା ମାଗିଲା। ଏହି ସମୟରେ ଦେବେନ୍ଦ୍ର ଦାସ ପହଞ୍ଚି ଏହାର ପ୍ରତିବାଦ କଲା। ଏହି ସମୟରେ ସୁଶ୍ରୀ ସଙ୍ଗୀତା ତାଙ୍କୁ ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲା ଓ ତାଙ୍କୁ ପେଟ୍ରୋଲ ପକାଇ ମାରିଦେବା ପାଇଁ ଧମକ ଦେଲା ଓ ତାଙ୍କର ମୁହଁକୁ ଏକ ଚାପୁଡା ମାରିଲା। ସେ ଗୋଟିଏ କାଠ ଫାଳିଆ ଓ ଲୁହା ରଡ୍ ଧରି ତାଙ୍କର ଘର ଆଗରେ ବୁଲୁଛି ଓ ତାଙ୍କୁ ଭୟଭୀତ କରୁଛି। So nothing against me, my lord.
506 and 34 is lordship is 34 is there.
And a subsequent statement, Rabindra Kumar Das.
ରବୀନ୍ଦ୍ର କୁମାର ସାର୍, ମୋର ନାମ ରବୀନ୍ଦ୍ର କୁମାର ଦାସ ଅଟେ। ଆଜି ତା 24/10/21 ତାରିଖରେ ଉପରୋକ୍ତ ମକଦ୍ଦମାର ତଦନ୍ତ ସମୟରେ ଏହି ବୟାନ ଦେଉଅଛି।
And thereafter again, Virendra Kumar Mohanty.
Same, my lord. Nobody has whispered against me in any manner whatsoever, my lord.
There is third line Vijay asi Subhasu ଘର ଭଡ଼ା ମାଗିଲା କେଜି ଜେଜି
ଯେକି ଦେବେନ୍ଦ୍ର ଦାସ ଘରେ ଭଡ଼ାରେ ରହନ୍ତି। ଏହି ସମୟରେ ଦେବେନ୍ଦ୍ର ଦାସ ପହଞ୍ଚି ପ୍ରତିବାଦ କଲା। ଏହି ସମୟରେ ସୁଶ୍ରୀ ସଙ୍ଗୀତା ତାଙ୍କୁ ଖରାପ ଭାଷାରେ ଗାଳିଗୁଲଜ କଲା।
First statement and what else? Apart from 161 statement, what else?
So, my lord, there is nothing against me. In the affair, the informant has categorically stated that today about 2:30 p.m. Susri Sangita and her associate Vijay come with our rented house. Our rented holder named Subasa. Vijay stay in downstairs. Susri Sangita come with Subasa in front of Subasa. Susri Sangita scolded me.
Yes, any material
With this level.
any other material.
first time come I have not along with all the copy of the CD or also but informant is
Okay, issue notice to opposite party. Yes, yes. Next.
22. Matrimonial after launch.
Pass over, huh?
Yes.
Okay.
23.
May I please over? Yes.
By quashing of the entire
Item
criminal.
22, my lord, I am for the petitioner. See, he has wrongly stated, your lordship. Item 22, I am for the petitioners.
22, somebody is asked for pass over.
No, my lord, I am for the petitioner. He has somehow wrongly stated. Item 22, I am for the petitioner. Even notice has not been issued to informant in this case. Nobody has appeared. He has wrongly
We are
stated.
appearing some other matter. Don't ask pass over in some other matter. Yes.
My lord, wrong.
Into 24. Wait. We have item 24. Yes.
My
Yes,
lord.
yes. Yes,
My
Mr.
lord,
Mishra.
my lord, I am for the petitioners, your lordship. The petitioners pray for quashing, your lordship. Quashing of
Yes.
the case. Where there is
Yes.
an allegation of cheating 420 against them. Your lordship may kindly see the order dated 11/9/2024.
11-9. Yes.
My lord, I have gone through this record again and again. There is no material to connect the petitioners with the crime. When I strongly submitted, my lord directed the government to obtain instruction. Now there is an online fraud. The informant says he has deposited 4 lakhs rupees in an account. Now from that account, it has gone to different accounts. That account doesn't belong to us. The different accounts do not belong to us. Mobile numbers used do not belong to us. Your lordship may kindly see paragraph. If page 7 I will read, nothing belong to us. My laptop, my mobile, everything has been seized. Not a single chat, not a single mail. How they connect with me with the crime, your lordship, is very
Yes.
strange, my lord. They called for my criminal antecedent. Police said no criminal antecedent. All through India, no criminal antecedent. Now, because in the my village, your lordship, the mobile location, so they arrested me and cash of rupees 50,000 seized from one of the petitioners, showing that he voluntarily gone to police and submitted that he has done it and cash has been kept in the home. No online transaction, no chatting, no email.
His lordship, the mobile number which the telephone was in which the WhatsApp message was sent by the informant by in common application form of that mobile number, it is came to light that the said person is using another mobile bearer bearing so and so number, lordship.
What about these three people? You just tell me.
Yes,
What are
lordship.
one after another. Tell me first accused. What are they? Vikas Kumar, Gaurav Kumar, and Bhola Prasad.
Yes, yes, yes.
Against these three people, what are the evidence you have collected?
Yes, yes. During investigation, lordship, the number which is a common application form, it has came to light that the said alleged number.
Common application for what?
For obtaining the SIM number, SIM card.
Yes.
No, my lord, it is not common application form, it is customer acquisition form.
Yes, that number, another the said fellow is using another number, so and so number, lordship. Thereafter, the police has collected the CDR, your lordship, of the said alleged number and came to found that the said man has using 4 telephone mobile numbers, your lordship.
Same man means who?
This present one, your lordship, the
No, your lordship. May I submit, my lord?
I'm passing it on properly. Prepare insofar as all these three.
there is some technical term is there, lordship.
You must tell me.
Also, let it come next week, lordship, from the IO in this case to explain all the facts.
You tell me against each individual what are the allegations.
Yes, your lordship.
And because charge sheet has already been filed, he says that there is nothing.
They cannot connect me.
Connect these people from with the crime.
Yes.
So you must tell me what are the materials against them.
Yes, your lordship. I will let it come in your lordship, next week, your lordship.
Yes.
In the meantime, I will obtain the specific instruction of the role and played by the present.
And all the one accused, what are the allegations and what are the materials?
Yes.
Everything you must tell me.
Yes, yes.
Yes.
My lord, may I submit, my lord? Since your lordship is not issuing notice to informant at this stage, your lordship, the learned lower court is proceeding. I may be.
See, I'll tell you, these are the very technical crimes.
Yes.
These are the cyber crimes. In what is your complicity in the entire transaction, nobody knows it.
My lord.
It is very easy for you to say that nothing is there. And the police, those who are investigating, they are also not equipped with the right information. They are also not able to, it is very difficult to connect. And every third day you have seen what is happening.
My lord, I do.
Cyber crime.
In this case, your lordship, in this case,
and unless a specialized investigating agency investigate, it's very easy for the accused person to.
My lord, in this case, on this basis, your lordship granted me bail on the very first day itself.
Maybe bail is something different. Bail,
may I only make a prayer, my lord? I may be permitted.
But quashing is not so easy. Let us
my
see.
lord, I admit, my lord, your lordship may kindly only permit me to seek one adjournment in the court below. Because the proceeding is going on.
Next week. Once I goes, then it goes on. Yes, fine.
When I please, your lordship. Petitioner placed for quashing of the entire criminal proceeding on the ground of compromise, my lord. Your lordship kindly have a glance. Annexed to running page 13. The informant has filed and compromise affidavit in ABLA number 2.
Investigation is going on.
Investigation is completed.
Completed. Where is the charge sheet?
Charge sheet is filed prior to 15 days back. So I am applying the.
Show me what are the offences in charge sheet.
Your lordship keep it for Tuesday. So
why are you doing all these things?
because the matter relating to Sundargarh, your lordship, for which
whatever may be, I am listing 100 matters and every matter you don't file the right document asking for adjournment. And you choose your date and time also.
because
Cases.
pardon, your lordship.
You get upon such a day at 2 o'clock. As if I have to leave everything and hear you.
Pardon.
In the compromise petition, you have to file everything. Do you have a charge sheet copy? I need to know what are the offences at least.
Offences is under section 376, 420.
That is an FIR. I understand that. I could see it. After charge sheet has been filed, what are the offences?
Moreover, the case has already been compromised.
In February. Yes.
Pardon your lordship, pardon me.
February. Nothing like. Yes. Next.
I beg your pardon, your lordship.
Next.
I beg your
Next. 20.
beg your pardon, your lordship. Lordship, kindly keep it for.
You don't understand what is the problem here.
I beg your pardon, your lordship.
As well, two-line paper to without writing anything, throw the paper on the court and you expect that
I beg your pardon, your lordship. Kindly keep it next week or 1 week.
376 are not passed on compromise. It's a case of 376. Compromise doesn't mean that you write anything and everything and it will be quashed.
I beg your pardon, your lordship.
Next 24.
Your lordship, keep it for 1 week after your lordship.
No, 1 week. It's not possible at all. 700 matters are waiting for listing. I accommodated you.
Because both had the
And very casually you are coming and
government employee, your lordship.
we'll see.
Keep it for
Yes.
1 week after me.
January last week. Yes.
24,
You'll have to apologize to me.
Password. Okay.
25.
You file the charge sheet, copy of charge sheet and mention after filing. Yes. Receive it in December. Unnecessary. I'm giving in December, but filing and tell me, okay. Yes. Yes, sir.
Case, May 2023.
Use the mic.
Yes. FIR was lodged on 3rd May 2023.
23. Okay.
Just 2 days after, the informant filed shown an affidavit before the executive magistrate saying that whatever allegations are made in FIR, they are entirely false because due to grudge. He has alleged the petitioners. Petitioners are two petitioners. One is 70 years old and second is 65 years.
But do you know the consequence? You file an FIR against these people, saying that the offense under section 302, 304B, 498A, 34, everything is.
I am the petitioner.
I understand it. And the same informant is giving an affidavit after 2 days, it is a false case. Then he has to be prosecuted for filing a false case against you.
That is her responsibility. So I should not be for that purpose. I should not be.
Yes,
But
mention my senior against us. So it's 302, this day offense.
That's right. 302 cases is right. He has an affidavit subsequently saying that
actually 302 is not made out.
whatever, investigation is still going on.
It's still progress because postmortem report shows something for which matter he is not able to file the charge sheet.
So these are the techniques may be employed by the accused persons to extract this kind of affidavit.
No, that would be whether it would.
Fact matter.
That's right. That's right.
Your lordship.
His father is not there. Brother is informant. Deceased brother is informant. And subsequently, your lordship is subject. He wrote everything. He deliberated how he has been stated before these witnesses that he has.
And when the FIR was registered, just see when the FIR was registered, date.
3rd May 2023. 3rd May 2023.
When the affidavit now.
Affidavit is 6th May 2023.
3 days. 2 days.
Because
the informant, the case are 3.
it is a false case.
Maybe false case, whatever. Maybe this affidavit is false. How do I know?
So if that affidavit is false,
And he was prosecuted.
that is her responsibility. I should not be
Notice, let us see. Let the informant come.
please.
I'll take the informant to task. If you have obtained this affidavit by exerting pressure,
Yes, I should
you face the consequence.
Yes, definitely. Definitely, I should to that extent.
Because you are relying upon this, saying that there is a compromise.
Yes, yes.
That means you have accepted.
If I have extracted, then definitely I will be penalized.
Please keep it after a week or so.
Your Lordship,
Huh? No. In this kind of situation, no question of protection. See, I have started doubting the affidavit.
Your Lordship, received on next.
Nothing is going to happen. I'll just put it. Investigation is still going. Huh?
Assessment disposed of with a liberty after cognizance. If investigation does not cause report by have a compromise report.
That's right. No. I want to go into the deep into it. Whether it has been obtained by him or that informant is given a false case. If a false case has been filed, she has to be taken to task. And if I have, so therefore I need to know. I am not going to quash it, but I want to go into the deep into the affidavit itself. Next week, huh? Next week.
In the meantime,
issue notice next week.
Because 70-year-olds.
That's right, but anticipatory bail is there. I can't. 302 case.
302 is not made out, your Lordship. Because
are you investigating? Who is investigating?
Whatever is coming out, whatever is coming
let the investigating agency come and say that no case is made out.
Kindly see the
FIR. Will say that.
Kindly see the FIR. What is made?
The investigation is still going on, sir.
Yes, right. The investigation. He is saying that let him say at what point.
1 minute. Call for CD and least next week. Huh? Next week. Yes. Yes.
26. Back, please, your Lordship. But who is the people?
After 1 week, you tell the investigating agency to look into this affidavit.
Yes. You know, the complaint to the police, and I want to praise my complaint class to proceeding because there is a compromise among the parties. My husband is the accused, and my mother-in-law is the accused. There is a 307 case, 323 previous allegation. For the document, my kids,
you are the informant.
I am both.
And who is second? There are two.
Informant is the one. Informant is who is the victim. Who is the victim? And the rest.
Joint petition then. Joint.
My lords.
Family dispute joint petition, 498 and all. Where are they?
My husband is in custody, my lord. Still is in custody. Since 2022.
22,
my lords.
In this case,
my lords.
Is it only 493?
What are the injury? Allegation is that by purely that allegation. Nobody also, my lord. But now, my lord, a small kid by a small boy, and
where is the informant? Informant and victim.
Where
are they?
Now they are getting their room.
I know they should come to the court. I want to
smilers. Yes.
See,
so very good.
Shall I put it on 26 or 27? 26. Huh? 27. 27. See.
And I am some personality 27. 26.
28. 28. Okay.
Okay.
Because the accused, see, how many accused are there by the way? And the custody. What is age? Mother-in-law?
87.
87. Okay. For her, you move an application for exemption from personal appearance, and both the informant has to be there. Okay.
27. 27, may I please, my lords?
The present petitioner has filed this application for quashing of the cognizance order. And the case is arising out of a Walsh's case manner. Cognizance order is at next step 2, running page number 23, my lord.
Come to the complaint.
Yes, my lord.
Complaint
starts from my lord annexure 1 series. Yes, running page number 13.
The occurrence and the occurrence fact of the case. Brief fact of the case.
So brief facts starts from my lord 14.
Yes,
my lord. My lord, the complainant himself says that the matter is.
What are the allegation?
Allegation so far as my lord, as per the complaint is concerned, the complainant has opposed the petitioner for the piece of land which he was interested, I have said him ki you give me this amount and I am in need of money and I'll give you a land. And he failed to comply. That's the same. And my lord, there is
You have taken money, RTGS and all this.
Yes, my lord. That is the allegation, my lord.
Yes.
And my lord, 11,30,000.
At this stage, only allegation will be there.
My lord, so far as allegation is concerned, my lord, only I'll satisfy whether the cognizance or the offences which has been taken, whether it falls under the prima facie or not, my lord. Because cognizance has been taken under section.
You promised to give a piece of land and taken money.
Yes,
neither the land is given nor the money. Simple.
My lord,
why are you going into deep into it? And the officer case is made out. Either you pay the money or face the consequence.
My lord, cognizance has been taken.
And you may later on say that it is a civil case, whatever. Yes, you fight it, but cognizance order. Cognizance order is correct.
Civil part I will come after that, but cognizance has been taken under.
What is the amount you have taken? You tell me.
11,30,000.
You pay the 11 lakh, I will pass it.
But at this
stage, you have taken the money, you have to pay it for. That's all. Don't bring technicality into it. You have taken the money.
But
these are honest transactions, you have to pay the money. I will issue notice subject to making deposit of 5 lakhs and I will send it to mediation and pay the money and finish it. That's the only way of doing it. Otherwise,
the transaction was made.
No transaction, it is all bank transactions. Just see.
Bank transactions were.
Just see. For your benefit, I will read it. Para 4.
I have read it, my lord.
Para 4 of the comparison. How will you get out of it?
My lord, but cognizance has, if your lordship subjected to acceptance, my lord, cognizance has been taken under section 294/50.
Whatever those things you argue at the stage of charge and all. At this stage, nothing can be done.
My lord, my issue is notice.
If you pay money, 5 lakhs.
5 lakhs, my lord, at this stage, my lord.
5 lakhs you have taken. It will be settled. He is not interested to send you to the jail. He is interested in his money. You complaint case he will file. Why don't you pay and finish it up? You have some difficulty, some installment or something, you will fix.
There are separate forums, as your lordship has rightly.
Then keep on fighting. Keep on fighting.
You just issue notice.
You have taken the money, now you are sending him to different forum. He will file a suit for recovery and all.
Lord,
that's right, but try to be practical. Should not be. You are burning the system. A suit will be filed and the court will try, and at the end of the day, you have to pay. Either in this proceeding or that
criminal proceeding should
pay 5 lakhs to begin with and send it to mediation and stay the proceeding.
1 lakh, my lord. At this stage,
even if you have taken, what are you talking? 50% I am saying. 50%. No. Issue notice to opposite party number 2, retainable loan so. The further proceeding in ICC case number, what is that? ICC case number 2300/2023.
Court of Learned Exchange.
Till next date of hearing, subject to petitioner depositing rupees 5 lakhs before the court of SDJM Bhubaneswar. Once the aforementioned directed amount of 5 lakhs is deposited before the court of SDJM Bhubaneswar, the matter shall be referred to the mediation center by the trial court for exploring the possibility of settlement. Okay. And release the matter after 2 weeks.
May I pray just one thing?
Deposit 5 lakhs, I am sending to mediation, pay
5 lakhs
and come and read good news, I will watch it. Yes.
5 lakhs the petitioner would not be able to. Any
it can't be settled less than 11 lakhs in any case.
No, I will come.
5 lakhs if you pay, rest of the money installment. I can finish it up. Yes, next.
Grateful, my lord.
Challenging the cognizance order dated 7/1/2020. My lord, the presentation not in bail in this case, my lord, my humble submission, kindly direct the present petitioner surrender before the law and trial court and move for bail.
Speak little louder.
The presentation not bail in this case, my lord. And my humble submission.
The bail application is rejected.
No bail, my lord, filed, my lord.
But who do the bail go? What are the offences?
204, 336, 34 of Petition.
What are the allegation?
Allegation against page number 9, my lord.
So tell me the allegation.
ନା ବାର ମାରିବା ପାଇଁ ତାର ବିଛେଇଥିଲେ ବାର ମାରିବା ପାଇଁ ତାର ବିଛେଇଥିଲେ
And died. Nothing can be done. That in the present petition is seeking quashing of the entire prosecution arising out of PS case number so and so under section so and so. I am not inclined to entertain this petition at this stage. Hence the same is dismissed. At this stage, we are talking about the petitioner submits that his client is willing to surrender before the court, and his bail application may be considered on the same day. Accordingly, a petition is granted liberty to appear of surrender before the court below by 15th of December 2024 and seek remedy available to him under law. If such bail application is removed, then can be considered on the same day. All grounds, including the ground of penalty, is available. Which
My lord's charges submitted.
Yes.
Under section 376 to 366A, 6 POSCO Act, and
Yes.
SC/ST PA Act.
Yes.
And petitioner, victim is already married matters. And both are compromised and dispute.
A compromise is all right, but
Already settled matters.
what is her age? No.
In the occurrence times, in the occurrence, 15 years.
15 years. Now, what is the age now?
Now,
The FIR is 2019. 15 years.
20 years.
20 years.
2021.
Give the copy, she let him examine, because that there is a judgment of Supreme Court now. You are not covered by that ruling. That's the problem. Just take it up. Give the copy, we'll see. Yes. Issue notice, reasonable. Yes. Now, let's examine this aspect. Now she has become in marriageable age. She is already married. What will be the consequence? Whether that judgment really hits?
That judgment, social impact.
Well, that is my judgment I'm talking about. Now the Supreme Court judgment.
Supreme Court judgment.
Well, it's a date of birth, not accurately.
Sorry?
Date of birth,
That I can't go into this proceeding. Just check it up if you can find it. Yes.
May I please understand? And so for questioning of the order of convenience as well as the NBW passed of the local on 22nd 7 of 2022, my lord.
20?
I see, sir, these are doing, my lord. At first 16 under annexure 2, my lord.
By where is NBW? There is no NBW.
I received at the 16, my lord.
Huh?
At the 16, my lord.
At the? Really, that's or 20th. I'll set aside the NBW, go and appear. And convenience order, I'm not going. Petition is agreed by the order dated 22/7/2024. 24, what is this? 24, 23? 24 only. 24. No. 23 must be. Cognizance is taken in 2023. NBW issued in 2024, January 24.
What is the remand?
Petitioner is agreed by the order dated 22/7/2023, passed by the learned JMFC R 2002 board. 2002 cognizance. 2023, 2002. Passed by the learned JMFC R. Whereby cognizance of offences punishable under section 341/323/307/34 IPC has been taken against the petitioner. Petitioner is also agreed by the order dated to 20/1/2024, whereby his application under section whereby although his application under section 317 bracket 1 of CRPC was allowed for that date, however,
That is another.
no.
That is another.
Again, also agreed by the order dated 20th/1/2024, whereby NBW has been issued against against him. Insofar as the first prayer challenging the cognizance order is concerned, I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all the points at the appropriate stage of the trial. Insofar as the second prayer challenging the order of issuance of NBW is concerned, the petitioner is directed to appear or surrender before the court below on or before the 15th of December and resort to the remedy available to him under law. Accordingly, the execution of NBW issued on such and such day by so and so forth. What is that? On execution of NBW issued on 20/1/2024, passed by JMFC 3, cognizance taking Kotak shall remain shall be kept in device till 15th of December, subject to petitioner surrendering of the with this observation petition. I just come. Any legal impediment?
That all accused persons are not found and joint affidavit is not been filed.
But joint with the
But where are the accused persons?
out of 6, two has come.
No, why the 4 will not come?
So, my lord, this is my lord, direct command, they will come. I am not saying it to them.
They have to come. They are upon their offenses, maybe not small offense.
Yes.
It has to be there. How can the in absentia how can I quash?
6 are with the accused persons, 6 in number.
The two those who are there, I'll quash it. For them.
So all 6 persons are before my lord.
Then bring them 2 o'clock. Online, let them come if they can.
Yes, sir.
Monday then. Monday? Okay, Monday.
So maybe my lord may examine so far the informant and the injured party.
Don't do it in piecemeal. We don't know. By seeing the informant, by seeing the other accused may say that no, I don't want to do.
Yes, I solve all that.
Monday? Okay. All right, shall I keep it at 4 o'clock today? You call them, I'll do it. Tomorrow?
One referral is there.
Are you sure that all the accused persons are alive?
They are there, but they are.
Sometimes, yes. Monday, yes. Next. And find joint affidavit also, meanwhile, yes. Yes. Yes.
Nothing on application seeking quashing of the FIR and pending proceedings. Allegations in the FIR relating to cheating. The Lordship would look at, before I take matters to the FIR, the contents in the FIR, but I have filed the certified copy of the FIR.
What are the allegations?
Kindly see page 50. The accompanying documents of the certified copy, but I take liberty to produce it. Certified copies.
No, I don't need certified copy.
You actually have the certified copy with the accompanying documents. In the FIR, the documents refer to 1 to 5. Kindly see page 50. These are the documents, but I am giving it.
This is
that should form part of the record.
Hard copy is not there. Then you have to file it if you want to rely.
I am not relying. That's for the purpose of
let us understand what
yes,
yes.
Now finally see the FIR. Finally see the FIR.
Yes.
Lordship will see this informant is the cargo lines. Page 12. Informant is the cargo lines. Informant claims that they are the landowner of these properties, my lord. They have purchased it by virtue of these sale deeds, cargo lines. It's a proprietary farm.
Yes.
Now the proprietors of this farm see complaints that the one Snehashish Das, not the petitioner, Snehashish Das, by virtue of the resolution which is said to be forged, has alienated those properties to some other persons, not the petitioner. Petitioner is nowhere connected in the transaction, nor that authorization, nowhere. Kindly see page 14. So far as the on plain reading of this part of the FIR, no case can be made out against the petitioner. Kindly see page 14. But while making all these allegations against Snehashish Das and batch of persons, she writes, it is the right place to mention here that it was built on private limited. It's a company.
How it has come to you? How the land has come to you?
No, it has not come to me. But I am an adjacent project owner. I have been unnecessarily, because let me show why she has named. Now kindly see the plain reading of this part of the affair. No case can be made out against me involving cheating. No case. She has unnecessarily tried to entangle me in this matter to harass me. Abhi the process of law. Kindly read this matter. You are making allegation. Kindly see. It's the right place to.
After investigation, what happened? Investigation.
Beg pardon.
Investigation.
She has lost. She has filed a civil suit.
Come to page 14.
Page 14. Yes, page 14.
Last paragraph.
Last?
Yes, last paragraph.
This is the relying.
It is the right place to mention here.
Yes.
The Evos Building Private Limited, represented through its managing director, so with accused, has started his project in the name and title of so behind Sushant Patra.
Yes.
And arrangement different plot of Evos Private Limited. So I'm sure that the calling occasion is
Let them show.
has invested money for execution of the first sale deed in the name of Sushant Patra, and he is the brain behind so and so, so and so. These are the allegations. It is subject to investigation.
No, kindly consider this. They have filed a civil suit.
Maybe, let it be investigated.
How can you do? You have let them produce any material from case diary, any private officer.
Let them do it. That's what I'm saying.
Let them bring it.
Let them investigate. Why have you come at this case?
I have come, the reason being, this cannot be an allegation. This is just a complaint.
No, you can afford to litigate, doesn't mean that you will come to this stage. Allegations are there.
Let me read it.
See, you are the beneficiary of this transaction, maybe because in front of the your project,
This will communicate.
I understood it.
No, this is not the issue. The issue is somewhere else. This informer's husband has cheated us by 6 crores of rupees. That's the issue. They have cheated us by taking 6 crores of money from me to sell some land. They did not sell.
Where did you say that?
Yes, I have said. I have lost the FIR. The FIR is page 15.
Yes.
Page 16.
The cross FIR.
Yes.
What is the stage of the
Here,
one investigation is going on in this case?
it is only to entitle them to their own internal issue.
So that's what FIR and cross FIR. Let it be investigated.
Investigation, but at this stage, I am saying, Lord, they have investigated. Let them produce records to show if at all any material is coming out against me in this case. Let them produce records, privacy, they have investigated.
Why should I at this
Produce the case diary, because case diary has been prepared. That's part of the investigation.
I am saying something else. I am saying in a better proposition.
Yes.
What I am saying is whatever you have, you go and tell the police, apprise those things, let them take into account every fact and deal with that. And decide whether they should file a form or report under 173, whatever.
I'll be little more safe. I don't want to. This is a completely first rate case against me. I'm a highly reputed person. Not my 6 source of rupees will lie with them. They have taken
Have faith on police. Police may file a form in favor of you.
Let me tell you what is the problem here. My kindly see my FIR, everything is on the curve. Now, after this FIR, after being released on bail, so as to twist my arm. But there are judgments. If you are making allegation against the managing director of a company, you must say what role played by him, what Sibo Sankar Mishra.
That's right, but the investigation is still going on, sir. At this stage, how will I know? And you want me to investigate?
No, FIR must say.
You have made some statement. You want that those statement has to be inquired by me.
No,
through police.
Let them come up with record to show that they have privacy material against me. Because they have instant case against me.
If they don't have, they will file a closure report. What is the problem?
That is the thing I am asking, requesting my lords. Let them produce the records to show that if there is any privacy material against me, anything, I'll go and approach them. My lord.
What is the stage of investigation in both the cases? I will not call for you. Have to tell me. I am not going to. I will not do his job or your job.
No.
I have to see the record and decide the case.
Yes. Let them get it.
Yeah. See, the problem is you at the nascent stage of investigation, you move application making a lot of allegations.
That will come out.
That needs to be gone into by the police.
That will come out from that record. Kindly consider. Let them produce the record here. If it is in nascent stage, as the lordship is proposing, I'll go back. But if the,
Get this. Get this satisfied
that is what I'm trying to tell you.
by 27th or 29th. 29.
That's what I'm just trying to tell you.
Just tell me what are the charges of this.
Exactly.
I will not interfere.
Not at all. If your lordship finds that investigation has been substantially done and nothing privacy is against me,
Then the cognizance court will go into it.
you may not.
The cognizance code will go into it. Thereafter, the charge code will go into it. And I can't scuttle everything.
No, I can't.
I give a go by to all the procedural court and everything and start doing it.
I will never tell you lordship to do that. I'll just from the record, if they are not able to demonstrate privacy case against me from the investigation, then I'll cite as dismissal.
See, 482 jurisdiction is not to interject in between the procedure.
Not at all.
The procedure is contemplated under law.
At least 4 judgments are there. Investigation is not called for. If on a plain reading of the affair, if the no privacy case is involved, just me. But let them produce the
Every case is different. Anyways, these are transactions, counter transactions, counter transaction, transaction. You allege so many things, he alleged so many things.
Let them come up.
Needs to be investigated and we can pronounce the case. 29th, get the status.
Right.
Yes. 29th, only for status.
32. Item 32 may be taken up after 2 weeks.
Sorry?
Maybe taken up after 2 weeks, Your Lordship. Item 32.
2 weeks, no. This will go a little late. Okay. February, yes.
Much obliged, Your Lordship.
Order of cognizance in 138 proceeding, my lord, is under challenge.
Yes.
So, Lordship may look at page 14.
Yes.
14. This is part of the notice I am praying, Your Lordship.
Yes.
I am placing, my lord. Last portion. It is therefore call upon you.
Who are you? You are the accused. Huh?
I am the accused.
MK Bhumi.
I am this land business, my lord. Builder, sorry. It is therefore call upon you, your client, to make payment of 40 lakhs, rupees 15 lakh 65,000, 3 lakhs 50,000 taken as hand loan, total 59 lakhs 15,000 with interest 24% after receipt.
Whose notice is this?
This is the complainants.
Complainant gave a notice to you,
my lord. Check bounce case, your lordship.
138 NI.
Yes, 130.
Yes.
So, with the allegation of this nature, the complaint may fail the test, my lord, 138 test. That is not the said amount. You can have several amounts, you can claim several amounts, but said amount is not there. The 138 said the demand should be for the said amount, the check amount. I am not saying that to the extent of saying that only that he will confine to the check amount. And in this case, my lord, I am fortified with the judgment of your lordships, also Supreme Court, which said, my lord, in 23, a scanning of annexure P.
Call up into you are reading there. Call up into you.
This amount.
Check amount is
40
lakhs.
40 lakhs. 15 lakhs 65,000. 3 lakhs.
There are 3 checks. There are 3 checks.
There is one check.
One check consisting of who? What is it? Where is the check?
It is not clear. That is why I say, my lord, I am relying on a judgment.
Various standards amount have been claimed.
No.
That is not true. And your lordship, before I take your lordship, the said amount, that is the language used, and that is what has been interpreted in this judgment. I will place your lordship.
What is in the date of this notice? 27/6/2023.
There is 2 parts to it.
1 minute.
27.
Where is the complaint? Where is the complaint?
Complaint, I could not file your lordship. I got a certified copy I've got.
Give me complaint.
And it is filed on 27/6. Repeat more, I That's your notice.
This is not the notice of 138. Just read your complaint. This is not the notice. You are reading some other notice.
Well,
this is not the notice under 138 NI. Read your complaint. Read the complaint.
There are 2 parts to it. The first.
No. Why are you saying that? This is not the notice under 138 NI. Which you are reading. Read the complaint. That's the reason perhaps you have not filed the complaint. Your entire case is based on the wrong notice.
One part, second part, my lord.
Why? This first part you get over first part.
Yes, I'm supplying a copy also.
You are instructing counsel has tried to mislead by filing this.
No, your lordship.
No, see the complaint. Then what was the legal notice?
I handed over the wrong notice.
Then you rely upon this notice is that a 138 notice. No, you withdraw it and file it.
No, that please, your lordship will file an affidavit by Monday.
Why are you doing this thing?
I don't know.
At this stage, you will do. When you are instructing counsel, don't try to mislead me at least. I know I can catch immediately within 2 seconds.
Your lordship may have a look at it.
Read the complaint first. Read the complaint last paragraph.
Last part.
Last paragraph.
In fact, circumstances stated above, this honorable court may kindly please to enough to allow this petition.
Refer to prior to that. Refer to which notice?
The opposite party given notice.
Dated 31/5. Read that. Read that. Legal notice. Dated.
And pleader notice sent on 31/5.
31/5 notice.
Aye.
ଆପଣ କୋଉଟା ପଢୁଛନ୍ତି 27/36
ମୁଁ sir ଭୁଲଟା ପଢୁଥିଲି. This is the notice.
and if this notice is read this is not in conformity with the requirement of 138 this notice but that notice where is that notice where is the reply
That notice I have handed over.
I withdraw it and file
Not withdraw your lordship, come up with the paper.
no
My lord, again I go back and will lordship.
there is frivolous petition so therefore I am saying
I am amended. My lord, Monday I will come with the.
why amendment you the amendment has to also go amendment is also wrong the entire petition is wrong
That is it.
entire petition is wrong madam Mr. Sadangi, senior counsel seeks to withdraw this petition to file a better petition with better particulars and documents. The petition is disposed of with liberty to file a fresh petition. Yes.
The certified copies may be.
Certified copy of the documents placed in this file shall be written to the instructing counsel of Mr. Sadangi by replacing the photocopy. Yes.
34th. Certified copy.
You be careful. While filing a petition, be careful. Don't make wrong statement. Yes, next. Yes, yes. Yes, sir.
In item number 34, I am appearing on behalf of the opposite party number 2, my lord.
Opposite party number 2.
My lord.
Okay. What do you want?
The matter has been settled, my lord, as they have already got married and a joint affidavit has.
That's the problem in this case. Marriage is all right, but
My lord, that will be filed today in course of the day. My lord, I can consider that.
I read the judgment, recent judgment of Supreme Court.
My lord.
Read it. How will you get over?
Well, actually, they have already got married. I have the marriage certificate.
That's right. Even if after marriage, the Supreme Court says that you can't quash it. I had taken a different view in my judgment, but now their view is taken by the Supreme Court. What to do? How will you get over that judgment? Read it and tell me. I'll just place it after 2 weeks. Read it. If you can find out the way, I can interpret. Okay.
As this, my only submission is that as they have got married, my lord, that is and
I accept your submission. I accept your submission. I don't doubt it. But even if I accept it, the judgment of the Supreme Court may come in your way. So therefore, please examine, find out particular sentence from the entire judgment which will help you, so that I can quote that and try to help you out. Read it again and again and again. Find out some sentences or some this thing, so that I can quote, and you have to get out of that judgment. Yes, do it after 3 weeks. Yes, take it. Yes.
35.
May I please, your lordship?
Yes, madam.
My lord, I'm in the VC, lordship. Lordship, I'm challenging the order dated 13/9/2024, Annexure 2, running page 16, Your Lordship. My Lord, which is the rejection order of the petitioner.
205.
My Lord?
205 application.
Yes, Your Lordship.
Yes.
My Lord, in the meantime, the charge sheet has been submitted. Preliminary charge sheet has been submitted under section 498A, 304B, and 306, 506, and 34 of IPC, Your Lordship. And my Lord, the petitioner is the brother-in-law of that. My Lord.
Yes.
My Lord, but petitioner is the brother-in-law. There is no such allegation against him, my Lord. And
yes.
And one of the co-accused, his mother-in-law, is already on surrender before the court, Your Lordship.
When the charge sheet is filed?
My Lord. Sorry, Your Lordship.
Yes, yes, madam. When the charge sheet is filed? The petition says there is nothing in the petition.
Lordship, only the FIR copy is annexed.
FIR file, then straight away she says that I filed 205 application. When the charge sheet is filed, what happened? Nothing. FIR is filed, thereafter 205 application, straight away. In between, what happened, nobody knows.
Lordship, from the FIR, it is evident.
And she is agreed by the rejection of the application under 205. What is the stage of trial? What happened? When charge sheet is filed? Nothing is there. How to go about it?
Pardon, Your Lordship.
Yes, madam.
Lordship, there is already this mother-in-law is already in bail, Your Lordship.
It's all right, madam, but I should know what is the stage of the trial, what happened, when charge sheet is filed, what is going on, how many issues are there, why your application under 205 is rejected, nothing is there in the petition.
Lordship.
How will I decide the application?
Lordship,
File a better one.
the rejection is on at page 16 and 17. Rejection.
Now, what is the stage of the trial?
That we don't have. Only the FIR is annexed here.
How many issues are there? When the charge sheet is filed, nothing is there. Right, the petition is briefed up for any particulars and without any annexing any relevant documents. So therefore, I am not inclined to entertain this petition. And the same is dismissed with a liberty to the petition to file a press petition with all particulars and relevant documents. You file a petition. Okay, you file a petition, I will entertain. I have given liberty. Yes.
Objection, Lordship.
May I please, Your Lordship? Here, my lord, I seek to quash the criminal proceeding.
Yes.
I seek to quash the criminal proceeding, including the order of cognizance.
Cognizance is 9/10/22.
My lord, I want to know.
What is the stage now? 22 cognizance.
Only a date is given, someone is issued for appearance.
Charge might have been.
No. Only someone is issued to appearance. It was posted to.
Yes.
Lordship, may kindly see the offense, alleged offenses are 468, 471, 420, 34.
You are Lalit Kumar and Damayanti Mishra, Jayanti Visoi.
Your Lordship, may come to the affair.
All the accused persons.
All the
yes.
It is a completely civil dispute. Allegation is made, Your Lordship, may kindly see the para 2 of the affair.
Para 2 of what?
Affair. Page 15, Your Lordship will get.
Yes.
The above noted accused person, the present petitioners, from serial number 1 to 6, surreptitiously sold 2 plots bearing such and such, a total 45 decimals pertaining to Khata number 141 of Mauja Holari Singha, Hon'Ble to 1 Sarika Agrawal, on dated 30/10/2021, fraudulently by impersonating me. It is very important, Your Lordship. And my sister led Kalyan Tripathi, who had already expired on such and such by virtue of an affidavit and no objection. Impersonating means, my lord, they must be present. Someone rather than those persons must be present before the registering authority. But no, that is not done. That is not the case. Only on the basis of, they say, during investigation, only on the basis of the affidavit filed, which has no connection with the sale deed. My lord, the transaction was made. So if at all affidavit will be considered and which is not come under the definition of the document, it has no value at all. So someone may tag with it, with the document. So Lordship, I have annexed that document.
Come to page 37.
Page 37, yes. Lordship, that I wanted to show to your Lordship. During course of investigation, I visited the spot, examined and other witnesses recorded statement under section 161 CRPC, seized the collected the related documents of this case, which well proved against the accused person, reviewed the case record prepared previously, and it revealed that there is a landed property by khata number such and such, Mauza Huluri Singha, Pest Town Desh Hon'Ble, which stands in the name of Panchadev Ratha and Hormone Ratha. Both the persons are died since long, but no partition of the said landed property has been made till date. However, the legal heirs are in possession of that landed property. Late Pandav Ratha has two sons, namely Durga Prasad Ratha and Kali Prasad Ratha, and one daughter, namely Kalyan Tripathi, who is married and expired in 2018. On the other hand, late Hormone Ratha has four sons, namely Lalit Mohan Ratha. These persons are the petitioners who have executed, who have right over the property concerned. Pradeep Ratha, Ashok Ratha and Dilip Ratha, and two daughters, namely Damayanti Mishra and Jayanti Bisoi. Now they are all staying separately in their respective places. But matter is that on 30/10/2021, the sons and daughters of late Hormone Ratha, who has a share over the property also, being together have sold two plots, Bhide plot number 394 and
Allegation is this is a joint hold property.
Right.
One of the shareholders for the property has died. Their descendants are there. You have manipulated the affidavit of and got no. You have said that they have no objection, and thereafter relying upon that affidavit, you sold the property.
No.
That's the allegation.
No, the allegation is the affidavit is sworn. Yes, that I am still saying. My affidavit has been sworn by whom? Affidavit has been sworn by two persons. Who is this?
They are impersonated. That's the allegation.
Impersonated. No, that they may be.
That things I can't put it.
Therefore, yes, why my I am submitting so. But when affidavit is made, they said that they have a shareholder. They have a share.
Yes.
Because they are the legal heirs of Panchadev Ratha. So their affidavit was made. My submission before Lordship is the affidavit must be a part of the document. If it is a part of the document, no.
Any paper which you have created fraudulently or mischievously to persuade the prospective buyer, saying that I am the absolute owner. Then there is an element of criminal knowledge. It has to be.
I am just therefore I have submitted. That is a point your Lordship has rightly understood, but the law doesn't say so. The law says that the document has to be presented before the registering authority, as per the section 58 of the registration.
Those things rightly. Not in 4 I can't go.
Yes, my I am saying one affidavit can't be affidavit sworn by two persons. Sworn by two persons, sworn and identified by the different advocate. It can't be part of the document. It can't be. If at all it is part of the document, then we are liable.
No.
Yes,
you are stretching too far.
No, affidavit.
These two affidavit which has been shown to the prospective buyer, they believe that to be true. On that basis, they got persuaded themselves and purchased it.
No, your Lordship, I am no. Your Lordship, I have annexed. Therefore, I have annexed this LD. Your Lordship, kindly see. I have annexed this LD. Therefore, my lord, I have annexed this LD. Your Lordship, kindly see this LD.
It is a well investigated case.
Your Lordship, kindly see. Come to page 61.
Yes. I think cognizance is rightly taken. You argue on this point.
Your Lordship, kindly see this. Yes. Your Lordship, kindly see.
I'll give that liberty. You argue all this.
No, your Lordship,
in detail.
Your Lordship, kindly come to this.
Cognizance is rightly taken.
No, your Lordship,
which one you want?
You press 61, your Lordship.
61?
61 of the cell deed.
Yes.
Cell deed, my lord, the two cell deeds have been executed.
Yes, I'm there. Exactly there.
Your Lordship, kindly see.
Right.
You also can see the paragraph, the description of the sale deed.
Yes.
If it is there, what is the requirement of the affidavit? Where is the schedule property more fully described in the schedule below?
Everything will not come in the sale deed. Sale deed, this may not be part of it. So you are persuaded by showing this affidavit.
No,
You are trying to say that the item of issuance of sale affidavit is not
who has shown
mentioned
who
in
has
the.
shown the affidavit, your lordship? Who has shown the affidavit?
Those things are
No, your
not
lordship,
facts.
just it is the part of the law.
Yes.
It is the part of the registration act. But who has shown the affidavit? Affidavit is of the two persons of the different shareholder. Identified by the different advocate.
Those have to be investigated.
Yes, it has been investigated. And it has, the affidavit is with different persons. It is not the part of the sale deed. How many we have impersonated and sold the land? We have said that has failed in our share and we have sold it. If it is so, and the registering authority has permitted for registration, what is the requirement of the affidavit?
Your Worship, at page 54, the 161 statement of the sub.
If it is not, we have said that we are in possession of the property, it has been partitioned, it failed in our share, and considering that now it is allowed for registration, so what is the requirement for the affidavit of the different persons? And this aspect has been taken care of by the sub-registrar. Affidavit is no more required for registration of the sale deed.
It was presented, Your Lordship.
Why it will be presented? Might be some.
It was presented.
Anyway, you argue all this point.
You lordship kindly see this.
You have any judgment?
Attempt was.
I'll bring judgment to that respect.
You
have act, registration act. The registration act says.
At the stage of cognizance, I need to point all these things. What are you talking
I
about?
have come forward, my lord, to quash that proceeding.
I know, I understand.
My lord. Therefore, my lord,
I need not go. See, prima facie made up argue.
why, my lord, why, my lord, I am stating. You know, take it in the different.
No. You argue, but at your exposure and stature, you can't.
No, you lordship kindly see. My lord, you lordship keep it in 27 or 28, not that.
No.
You lordship kindly see.
If you want to say anything, you can very well give in writing. I reserve judgment.
You lordship kindly see, baby, section 58.
I think don't prejudice your client. The better thing is I'll give full liberty to you, move an application, and I'll direct the trial court to deal with your.
Keep it to 27 because one of
Please.
My lord, one of the.
I'm giving you full liberty. Move application, and all the points will be dealt with.
Petitioner number 1 is a senior advocate of the Honorable Bar.
Maybe.
Therefore, I am saying that you lordship may take 27.
That is more of a reason that I should not interfere.
No.
A senior counsel giving an affidavit persuading
They have not done that. They have not done that. Law says that they cannot. Law says that they cannot. Therefore, I am saying, I am stressing up. Otherwise, not. You lordship may keep it 27. So that I will take instruction.
Prima facie an attempt was completely made to.
That's right. I know.
Moreover,
I know. It's nothing.
No, it is not.
Sir, best thing is I'm giving you liberty. Argue all this point at the stage of
you lordship may
an application.
You lordship
To that extent, I'll give you.
You lordship may pass the same order, but on 27. You will take instruction to the lawyer counsel.
Okay. On the request 27.
27 you lordship may take.
But 27th will be the same day again. I'll have the same view.
No, I will not.
Anyway, it's all right. All right. 27. 27.
37.
37. Yes. Pass over.
38.
Yes, sir.
But in this case, the petitioner, who is the first party in a proceeding initiated by her under section 145 of the CRPC,
yes,
was disallowed by the learned magistrate contrary to the statutory provisions, wherein it is provided that irrespective of right title interest, the learned magistrate is to declare the possession of the petitioner until she is ousted through process of law. But the learned magistrate, by the impugn order, has held that he lacks jurisdiction.
Where is the impugn order?
Well, the impugn order is at page 66 passed by the learned magistrate under Annexure 10.
Yes.
The relevant part is at page 77. 77. 14th line I am reading with your lordship's permission. 77.
Yes.
Due to lack of jurisdiction, this court cannot adjudicate the dispute.
77, where are you reading, sir?
14th line, my lord, from top 14th line. Due to lack of jurisdiction, this court cannot adjudicate the dispute. All these facts can be adjudicated before the competent civil court. But the statute provides that the learned magistrate is to declare the possession of the party. Three questions are open to the, in view of our decision of our Honorable High Court. The magistrate
145.1, the magistrate has the power to declare that you are in possession.
145.4.
4, yes.
4. My lord, 145.4.
Where is show me the judgment? Show me state by judgment.
Judgment. Already the judgments. Our Honorable High Court has held I have highlighted 3 courses are open to him under section 144, 145 and 46 of the code. Firstly, he may decide that one of the parties was in possession as referred to in section 145. Secondly, he may decide that none of the parties was in possession, in such possession. Thirdly, he may say that he is unable to satisfy himself as to which of the parties was in such possession.
This is Calcutta High Court judgment. Odisha High Court judgment.
Well, this is the our High Court, Honorable High Court decision, 1991, volume 72, Katak, LT 364.
What are the evidence you have laid?
My lord, evidence he did not allow. I filed my evidence affidavit. I have annexed that. He did not allow and he proceeded to dispose of the case.
I'll issue notice. The judgment, I am not, I am personally speaking, with due respect, I am not agreeing with this judgment, but since there is a judgment, personally, my view, but I am bound by this, I am issuing notice.
Well, this is, I have got, this is for the Honorable.
These are the,
this is for the Honorable Court.
That's all right. Keep it. Top copy. I'll just rely upon the judgment. See, possession issue has to be decided by a civil court. Declaration that you are in possession or not, how a executive magistrate and 145 can arrive at?
But statute provides for inquiry.
Inquiry, that is a prima facie view. The possession declaration can't be given.
There will be evidence.
Anyway,
cross-examination.
Judgment says that. So I'll go by that. Right. Right. Petitioner is you are the complainant.
First party petitioner.
First party. Petitioner is the first party complainant. In what is this case number? What is this case number? In criminal miscase.
In the CRLMC number 1297
of 2023. Before the executive magistrate Katak initiated under section 145 CRPC. The proceeding was not entertained by the learned magistrate and dropped and passed the impugn order dated 29/8/2024, dropping the same, saying he lacks jurisdiction to decide regarding the position of the petitioner in the landing subject. Land counsel for the petitioner relied upon the judgment of this court and reported in so in para so in para. Thereafter, 3 courts is open. 3 courts is last one. relying upon the judgment in Supra, the learned counsel for the petition submits that the recourse open to the executive magistrate to entertain the petition under section 145 has not been opted by the executive magistrate and drop the proceeding. Issue notice to opposite party number so and so returnable at so and so.
Well, that is IA for interim protection to maintain status quo.
What interim protection?
Well, my possession is not to be disturbed.
It is not even decided. He refused to decide. How will I presume that you are in position?
There may be status quo. As on today,
I can't do it. Your whole grievance is he has not decided the position, who is in position. How can I protect you? He dropped the proceeding, saying that I will not go into all this question.
I lack jurisdiction.
And in that situation, I will just, if at all I am convinced, if the judgment is there in your favor, I can very well restore the 145 petition to decide, resort to any of the three courts which is available under the judgment. That's all. I can't pass an interim order to
my humble submission. Until then, the property is to be kept in status.
I can't do anything because I am not adjudicating anything. This proceeding, I am not adjudicating anything. The adjudicating court is the executive magistrate who refused to do it.
In IA also notice maybe. Both.
I noticed on IA. Yes. Notice. Better serve immediately so that I can dispose it up. Yes.
Your Lordship, may I please?
File the process by tomorrow. Sir, file the process by tomorrow so that notice will go. File the requisites by tomorrow. Yes.
Belgium, Your Lordship. Here the petitioner is 74 years old, Your Lordship.
Belgium. When the issued on
26/2013. NBWC
500. Yes.
Oblige, Your Lordship.
200 December को ठीक है. Yes.
40 May, please, Lordship. Lordship, petitioner, before your Lordship, with very limited prayer, petitioner wants to target the proceeding of CT case number 551 of 2020, which is
20. When charge sheet is filed?
My Lord, charge sheet is filed 15/9/2021, and after that, cognizance has been taken.
How many witnesses are there?
My Lord, till date, no charge has been framed.
How many you want target?
My Lord.
I need to know how many witnesses are there.
Lord.
How many documents to be executed, exhibited. Nothing is there. How will I target it?
I don't have the copy of the charge sheet, but my Lord.
Suppose 200 witnesses are there. I will target it for 2 months. What will happen?
Until then, the victim is not rescued. And the accused petitioner were filing time petition since 2021, and the next date of the proceeding is 7/1/2025.
25.
My Lord, till 2021, the matter is pending. And the accused person were filing again and again time petition and taking time.
They are on bail.
My Lord.
You are agreed by what?
My Lord, I am agreed by the
which order?
I am not agreed by any order. I am the informant, and my daughter-in-law has not been yet rescued, and the trial is still pending not yet started.
You are the informant.
My Lord. The charge is not framed.
I'll just record for the sake of it, but I can't target it.
The prayer is to dispose of the city case.
That's right. But what she says, just see the proceedings she has filed. The trial court is simply adjourning, giving, just see the proceeding. Trial court is simply adjourning it. She agreed.
Frame may be issued.
And now the date is fixed on January 2025. The last, the matter was taken up September 2021. After September 2021, direct to 2025. What is this? The last order, I don't know why this matter happened.
There are 10 number of accused persons. Against them, cognizance has been taken and charge not yet framed, my Lord.
What I'll do is I'll ask for a report. Let us understand why this is what is this going on. I'll just ask for a report from the court. Maybe in between some proceedings are missing in this.
Oh, my Lord, the last dated of 15/9/21, and then after if my lord will call for the record, thereafter 3 years of.
Are you sure that entire proceeding? This is the entire proceeding. So I'm surprised in 2021 last proceeding thereafter.
I have given the entire order sheet because of that. This is a bulky order sheet and the entire dates or time petition given, accused were absent, time allowed.
Okay, I'll just ask for report, right?
My lord.
STJM Udala
Udala.
is maybe the registry directed to obtain a report from STJM Udala in which case? In
CT case number.
CT case number
551 of 2020.
Start us the trial, by next date appearing, least after 1 week. Yes. And just let us understand.
My lord.
Yes.
41.
May I please?
Yes, sir.
Against the cancellation of bail.
Cancellation of bail?
Yes.
Why?
The husband and the in-laws family, and the in-law family, they face the trial. During pendency of trial, even if most of the witnesses have been examined from the side of the informant. Even the informant has already been examined. The date on which the informant was examined and thereafter also the independent witnesses have been examined. Before that, another FIR has been lodged by the informant in some of the RPS police station that the husband, the present petitioner has threatened him and assaulted him, asking him to withdraw the cases, drop the proceeding. The date of lodging affair was January 24. Thereafter, he was examined in the court. He did not disclose regarding the threat. Even if the other witnesses have also not disclosed.
Come to the point, what you are trying to say, if I correctly understood, is the informant while facing the trial.
Yes.
Has now registered a FIR against you.
Yes.
Therefore, his bail has to be cancelled.
My bail has been cancelled.
Your bail has been cancelled.
My bail is
then you apply for the fresh bail.
The ground of rejection. Ground of rejection.
Where is that order?
The entire order sheet under Annexure 1. The cancellation order is starts from page 26.
Against you might have influenced the informant. So that's the reason.
Influenced the informant.
Yes. Show me.
The order dated 5/3/2024 starts from page 26. 26. Running page 26. City case number, city sessions number 13/19.
After marriage,
the record is put up today. Today for the order of petition filed by the learner APP on behalf of the informant for cancellation of bail in presence of in respect of the accused Abhimanyu Rai, the present petition. The learner defense counsel filed objection to the said petition.
When bail was granted to you?
Bail was granted on 23/8/2018.
2018.
The direction in 438 by this Hon'Ble Court.
Okay.
I was granted bail on 23/8/2018. Then,
when the FIR was registered?
FIR was lodged on
against
1/2/2024. 1/2/2024.
Okay, I see what
before that.
I understood it. What I'll do is, I will not interfere, but I'll say that this will the cancellation of bail by the trial court shall not preclude you from renewing your bail plea. If bail plea is renewed, then that should be decided on merits.
On merit again, you have
already given anticipatory bail by this court. You will get bail. What is the deal? This otherwise, what happens is your bail is cancelled now, so you are in custody. You will be in custody. You will be in custody, and you are losing your right to approach the court once again. So therefore, rejection of recalling your bail application will not preclude you to renew your bail plea afresh. That's what I'll say. It's simply that suffices the purpose. And everybody is saying, your senior friends are saying yes.
I was directed to surrender before the
whatever.
on my
But that will not preclude you.
I
understood. Right on. Petitioner is an accused in FIR number so and so. Petitioner is facing trial in connection with the PS case number. All PS.
All PS case number.
Sorry. What is the original case?
The original case is City Sessions number 13 by 2019, arising out of Binjarpur, Binjarpur PS case number 260 by 2017.
Petitioner has been the petitioner approached this court by filing an application for anticipatory bail, which was allowed on 23/8/2018. The petitioner has been facing trial in the aforementioned case. While the matter stood thus, on 1/2/2024, the opposite party number 2 informant registered a case against the petitioner, being all PS case number 84/2024 for alleged offence under section 341, 220, 294, 323, 506, and 34 IPC. On the basis of the FIR being lodged against the petitioner, at the instance of opposite party number 2, an application was moved for cancellation of his bail. Accordingly, the trial court, wide order dated by the impugned order dated
5/3/2024.
5/3/2024 has cancelled the bail granted to the petitioner, and issued process for issued NBW against him. Against him. The petitioner is agreed by the same and has filed the present petition. I am not inclined to entertain this application, this petition at this stage. However, it is made clear that cancellation of bail by the court below on the ground that an FIR has been registered against the petitioner by the informant opposite party number 2 shall not preclude the petitioner to renew his bail plea after the petitioner surrenders pursuant to the impugned order. At this stage, petitioner counsel for the petitioner submits that submission instruction that the petitioner would appear surrender before the court below on or before 15th of December 20 and resort to the remedy available under regarding head to the statement made at the bar and bar the NBW. The execution of NBW issued wide order dated 5/3/2024 shall be kept in abeyance till 15th of December, subject to the condition that the petitioner shall appear before the court by the date already fixed. Already fixed. On or before 15th of December, and resort to the remedy available to the court.
Sorry, on my part. Now that FIR, subsequent FIR is not existing because of that has ended in final form, taking this false faith. It is the
those things are the best thing for argue.
That FIR has been closed
Then counsel for the petition also submits that the FIR registered by the instance of opposite party number 2 against the petitioner, which was made basis for cancellation of bail, has ended up in a final form. Final form by
the IO
on
on 26/4/24.
26. Therefore, he submits that the basis on which the FIR was a basis on which the bail was cancelled is not available. Basis has gone. Basis on which the FIR has been bail has been cancelled is no more available to the opposite party number 2. Okay. Yes.
42. Okay.
Yes. I have given more than what I supposed to give. Yes.
Maybe bigger personal. Let the essential point for RCP is that I challenge the PMLA proceeding or prosecution and its consequential order of taking cognizance. Squarely on the point that the predicate offense, it is a PMLA is sprouted out of the EOW case, which is vexed before this honorable court in CRLMC number 339 of 24, where this honorable court has already admitted and stayed the proceeding. Therefore, my humble submission, I
thought you would be saying that it is quash. If you quash, then I would have said it.
And I both the matter before CRLMC also before Lord Similar, that when the foundation is removed, the superstructure that is
not removed, only it's not removed. It is yet to be examined, and if then you have a case.
Yes, therefore it may be tagged up the CRLMC and may be taken up any day to below.
Because let us see, if it is quash, then the story will be different.
Yes.
Story will be different. It's not even a quash. Not even a quash.
Pending and matter is state. No quash. But it is
I'll take it.
The point I'm vouching before Lordship is no mere that the EOW is a predicate offense.
That's right. So
yes,
that is being examined by another court saying whether or not. If it is quash, then you have a different case. If it is not quash, you can't.
No.
Yes. That's. And will you hold on? Hold your hands.
We have already filed complaint. Court has taken cognizance, summons has been issued. And my instructions are they are not appearing. The consequent direct them to appear and then go on as per personal judgment.
That's true.
I will not say anything. I'll just tag it and leave it.
No policy, but that proceeding has been stayed. EOW case was stayed, unless the prosecution, further proceeding in PMLA is stayed not, or no policy.
What he says is only summons are issued. You go and appear there. Go appear there, you will be out there. And thereafter the proceeding will be stayed.
I'll appear and no proceeding.
I will stay subject to you are appearing there. I'll stay the
yes.
I'll stay the proceeding subject to you appearing and resort to the remedy available. Right.
And maybe that to CRLMC.
Yes, right. Petitioner is in the present petition. Petitioner is seeking quashing of the complaint.
Yes, complaint
number PMLA case number 6 of 2024, initiated by the respondent under section 45, read with section 44 of a PMLA Act 2002. On the ground that the predicating offense, being PS case number EOW.
Yes.
EOW PS case number 6 of 2020, pending in the court of OPID Cuttack, in the designated court OPID Cuttack, has already been stayed by this court. Stayed by this court. Yes. The petitioner had filed CRLMC 2339 of 2024, assailing the predicating offense, assailing the initiation of a predicating offense against them, against them or him?
Against them.
Against them. The coordinate bench of this court, by the order dated 2/7/2024, issued notice to the prosecuting agency and also stayed the further proceeding in the predicating office. On the
Proceeding has not been stayed.
That's no proceeding.
and pass an interim order.
Yes.
Interim order of no coercive action against the petitioner. Relying upon the said order, let counsel for the petitioner submits that the PMLA proceeding may also be anyway, the present petition may also be tagged with the said CRLMC. I don't take issue notice to Mr. Agarwal, accept notice and tag the matter with this CRLMC 2339 of 2024 list on when is the date fixed there? Yeah. When is the date? Do you have any date fix in that case?
That is last date was on 25th. My instruction last date was on 25th May.
16/24.
They are not.
On
Originally
16/7/24 by date.
And thereafter one, what is it? There is no date. Least in January. First January.
They ordered to
Yes. And in the meantime, further proceeding in PMLA case number 6 of 2024 pending in the court of special judge Khurda, special judge under PMLA is stayed subject to petitioner responding.
Stay the proceeding because let them appear.
Yes,
That's what I'm saying. Subject to the petitioner appear in person to appear before the PMLA court pursuant to the summons issued on.
Summons issued on
Issued on such and such day and resort to the
issued on 16/5/2024.
16/5/24 and resort to the remedy available to whom under law at this stage.
Your lordship may not stay the proceeding, your lordship.
Subject to the appearance.
Because I think they have also not appeared because
I appear
in some of the accused have
No
not
coercive
appeared during the investigation.
no coercive action shall be taken against the petitioner subject to petitioner responding and appearing to the appearing before the PMLA court pursuant to the notice dated so summons so summon dated so
And also
and resort to the remedy available to them under law at this stage.
cooperate with the investigating officer.
Needless to say that the petitioner has to cooperate with the investigating agency in the meantime. Yes.
Next item 43 million. Next item, which is OPID matter. First time listed. Name also and referred to any other thing.
Malats, may I pray let it reach Malats, Mr. Kanungo is Mr. Kanungo is to argue
43.
43.
First time listed in the name of the Mr. Bhuya.
You are appearing for whom?
OPID.
Oh, Mr. Bhuya is not there.
Yes,
May I pray let it come after lunch, Mr. Kanungo is on his legs. He's
There is a request after 2 weeks.
next week, Malats, because
Any day.
Malats next week.
Okay, next week, 29th.
Item 104.
Name of the Mr. B.
Mr. Bhuya.
Item 102, my lord. That may not reach my pay for next week anywhere.
We reach also, we don't know. Sometimes board collapse.
No, that. No, because I am to.
Regular matter.
Yes.
This is
148.3 matter.
weekly.
Rejection of 1 foot. The supplementary matter. Item 102, my lord.
102 supplementary. Just see. How many matters you listed today? 107. 102 adjourn call.
Let's keep it next week.
Yes, Mr.
66, your lordship.
Next week, any time, or the week after.
He will give it.
Tracking report is there. If it is sufficient minors, maybe
Just see. Tracking report. Service is complete or not?
Not sufficient.
Not sufficient.
Tracking ଅଛି ନା? ତଳେ tracking ଲେଖା ହେଇଛି।
Item back.
Tracking ଟା କିଛି ନାହିଁ।
Fresh steps.
Fresh steps.
With corrected.
Awaiting service.
Then, my lord, I will pray for a stay.
Satisfy me.
On the first day, because I have filed a case in Delhi, your lordship, that
Then I'll hear you. I'll hear you.
it may not reach tomorrow because
No, no. Today it will reach. I've already.
and 91, that date has been fixed in the mediation on 26th, so date after 20.
After 26.
91 is the
Mediation still.
91 to 96.
So the mediation report is awaited. Please the matter after 26th, any day. I'll give one more week in between. Yes.
तापर आउ गोटे डेट भी हेई पारे सेट डिसेंबर दियो
December देली, हाँ?
कि जनवरी दे ना डिसेंबर
No, December. Yes.
मिड डिसेंबर
Yes. Is there any chance things are moving
कथा
positively?
लास्ट डे रे रहिले ने मीडिएटर तांग मेडिकल इश्यू हे गला
अच्छा, ठीक है. Then there is a chance. Okay. Yes. Thank you. I'll adjourn it because Mr. Sharma is not prepared. It can't be heard piecemeal.
Two accused.
I know it can't be heard piecemeal. I'll recommend it. In any case, today the board is also heavy, so I'll not take it. Yes.
With my lord's permission, if I may mention item 97. Item 97. Lord, there is a quashing petition, my lords, against a private complaint. My lords, they are arriving at a settlement. If my lord may give me one chance, around 3 weeks. Lord, trying to arrive at.
Let it come on its own turn. We'll see. The mentioning at 2 o'clock has to be discouraged. In the morning you have mentioned, again at 2 o'clock mentioning another half an hour wastage. Yes. Let us start. Pass on.
Item 6.
Yes. Item 6. That has not come. It hasn't come on record. I'll take it up next week. Just check it up why it has not come. Check it up. Okay. Next. Yesterday file. Okay. No, don't mention after 2 o'clock because mentioning unless it's half an hour.
It is not only still. Only 63 permitted to withdraw to file discharge.
Okay, so 63. Mr. Council seeks to withdraw the petition to file application under section 227 CRPC for discharge. Okay.
Okay.
This liberty. Yes. 63 gone. Yes.
Item 7.
Yes. 7. Yes, sir.
Rejecting the application filed under section 457.
Yes.
Facts of the case is that case was registered against petitioner by another lady who claims her as the second wife of my husband. But I had gone to police station to lodge the affair. But there also I came to know that she has also come to lodge an affair against me. Accordingly, when her case was registered against me and against her also. But I was there in the police station and police seized a bag containing gold ornaments, my gold ornaments and my Aadhaar card, PAN card, everything.
What is the reasoning of rejection?
Ascribed by the High Court.
What you are asking for release of the gold ornaments only?
Some gold ornaments out of the lot. But they have why not you kindly see order dated 27/2024 and it's a 4 page.
Yes.
This order arises after a petition filed by the petitioner named Archana Patra, wife of Dinesh Patra. At present, praying there is to release one gold shoe, one pair, 2 gold chain, one having locket, gold sankha, one.
Have you filed proof of the ownership?
Yes, well, that is the important question which I have instructed validly.
That's the important thing.
But on that score, it has not been rejected. Actually, rejection.
But you file it here, I'll just see and allow it with an undertaking that as and when it is required, you will produce.
Yes.
Simple. Why to go into all this thing? It's gold ornament. Why you need not keep it. As and when required, they produce with this undertaking and I'll release it.
Yes.
Very simple. You establish or shall I set aside and relegate you to trial court to move appropriate application so that he'll establish. Yes, some point.
After filing the application, call for a report from the investigating officer. Investigating officer says, I have seized the gold ornament so and so, but I have not seized the Aadhaar card, PAN card and other articles. The articles which have been seized from me, that has been given demand to the informant.
Now it says this court doesn't have jurisdiction to release. What is this?
May not be kindly see. What has been said? Peruse the case record, ballot page 25.
Yes.
Peruse the case report, the record and documents submitted by the petitioner. A report in this regard was called for from IO of this case, but in this report, the IO submitted that claim gold cured, one parent, one check, one same is left in Jimar, the informant of this case. Seized by the IO and the same is left in the Jimar, the informant of this case. The other claimed articles such as Aadhaar card, one PAN card, one voter ID, one ATM card of UCO Bank and
Have not been seized by IO.
It has not been shown in the seizure list. I have given the seizure list.
So the gold ornament is with the informant and these articles are not seized. So therefore the court says, no, I can't do it. What to do?
But if my ornaments, which is the subject matter, whether ballot, the question which ballot could be that whether you have got married documents.
It is given in Jimma only.
Ballot Jimma, it will not be available during trial. Who will be responsible for that? If you
challenge that Jimma order. 457 is not maintainable, rightly. So, where is that Jimma? Jimanama, you challenge that Jimanama. If it is seized from your position, how it is given to complainant?
Complainant is he is the accused, my lord.
Huh?
This petitioner is the accused, my lord.
That's right. He is also an accused.
That their affair is not with.
Who are you to take decision? You take all the seizure amount.
Court has
give to one person.
Court has taken decision.
No, court no. Court has not done it. It seems IO has done it.
IO has stated that we have given this. Court will ask to produce, and after satisfying that this.
What is it?
You file responsibility. File response. Okay. And issue notice under whose Jimma it is there, according to you?
Informant.
Have you made the informant as a party?
I paid for a party.
Where is that item? Which item? 7. Where is
Pilot will see.
No, you have not made the.
Archana Patra.
Where is it? Archana Patra is the. It is you. Is the.
And more number of hospital Patra, Swamika Nam Dilip Patra. My husband is Dilip Patra.
No, in corrected matter.
Page 14 is the FIR.
No, I am talking about have you made the informant as a party?
Informant party.
Otherwise, how notice will go? He is necessary party. Necessary party, right on. Mr. Dhal, learned counsel for the petitioner, senior counsel for the petitioner, seek leave of this court to implead informant as opposite party number 2. Memo parties may be filed within 2 days. Issue notice to the newly impleaded opposite party number 2, Mr. Jena, accept notice for the state, returnable after 3 weeks. File the amended memo parties. Yes. Next.
Other case also same.
Amended memo parties and issue notice. Yes. Next.
Item 9.
9. Yes, sir. Not next week, it will go to February, yes, next.
The bag
Huh?
So?
So, what to do? He is filing and I have accommodated and asking for adjournment, what to do? He doesn't want.
Next week, in the
Why next week? Why not today?
I think that I can do.
Now let them suffer. Let them suffer. 103 matters are there. I have accommodated you still. You should have little respect to the this thing. Yes, lease it after 2 weeks. Yes, next.
14.
Yes, 14. Yes, what is this?
Here is the case, the present informant filed this petition to add the 6 OPID Act in the port. Here is the affair has been registered for commission of
non-appeals for the petitioner, lease the matter in February. Yes. And in the second non-appeals for the petitioner, even on second call, in the interest of justice, adjourned to February. Yes. 15.
May I accusers?
Yes.
No, this petition is not the charge sheeted accusers.
Yes.
And it is my second round litigation. In the first round litigation, what happened in this case, Lordship, when the petitioner is in a service place, Lordship, not in the occurrence place, there is false allegation made against him that he has been committed the offences, Lordship.
Yes.
They are not challenging the same, Lordship. I filed an application before this court. The internal page of the petition, page 7, order dated 1/5/2023, criminal measure 1387 of 2023, Lordship.
Yes.
There this court is given direction to the authority concerned where I am serving to collect the CCTV footage, and there are the procedural according to the investigation. So CCTV footage has been collected by the investigation agency and found I am in the time of occurrence, I am in my duty. I have never been in the occurrence place, Lordship.
Yes.
So thereafter the charge sheet finding, Lordship, have a glance.
Yes. Meenaketan Panj.
Yes. That is a Lordship charge sheet finding. Page 32 of the internal page.
Yes, I am there.
During course investigation, visit the spot, examine the complaint, other witnesses who will prove the occurrence. WSI Madhusmita Singh of Jaleshwar PS recorded the statement of victim Kumari Onam Jana. 9 I issued injury equation in favor of injured Onam Jana to MO GKB Hospital, Government Hospital, Jaleshwar, and obtain injury opinion in which Dr. BK Pradhan, MO GKB Government Hospital, Jaleshwar, opined that the injury are simple in nature, caused by a hard and blunt object as the punishment for the offense on 7 years served notice on 41 years.
Yes, I read it. Yes. What do you want to say?
My respectful submission was last portion, Lordship. Last portion. Why I have not been charge sheeted, Lordship. I seized 116 GB high-tech company pen drive containing CCTV footage of Mon Automobile on production by Panchuko Pardas, who is the owner of the such automobiles, under proper seizure list, verified CCTV footage of and found that the alleged accused Deepu Bhanjo, my name is Lordship Deepu Bhanjo, alias Meenaketan Bhanjo, Lordship. Deepu Bhanjo is not in Deepu Bhanjo is reached at about 9:48 AM upon the grill gate at about 9:15 AM of the showroom. Left for lunch about 12:02 PM. Again, Deepu returned to showroom at about 3:35 PM. Locked the shutter at about 5:30 PM. So this is the finding of the investigation. Now it's the occurrence time also. The date of occurrence is 4/3/2023 and the time of occurrence 11:30 AM. By the time I am inside the showroom, Lordship. The similar case, other goods, this all good issue.
Now what happened there?
Now the cognizance has been taken that I am one of the accused over the case. Issue no, someone has been issued.
Cognizance is taken in the same.
Yes, no, the cognizance order has been challenged here, Lordship.
Yes.
That is Lordship order dated 4/12/2023, Lordship. For this, Lordship, the coordinate bench pass interim or so far co-accused person concerned. And if your lordship, in view of the direction given by this one court in earlier criminal miscase, your lordship, that verify whether my veracity regarding my presence in so far the occurrence place or inside the showroom where I'm serving.
See, your entire case is you have taken the plea of alibi.
No, this is not the plea of alibi.
Plea of alibi is also a fact. That's what I'm saying.
Because of that plea of alibi can I?
You have argued the case. You are against.
No, this fact, your lordship, taken into investigations by the investigation.
That's right. It is see plea of alibi, and on the basis of the CCTV footage of that showroom.
Yes, my lord.
And IO says that you were perhaps not there at the time of incident. And no,
I'm not there. I'm inside.
No, charge sheet is fine.
Yes, my lord.
But the court, while taking cognizance,
yes, my lord,
and taking cognizance against you,
yes,
on the charge sheet,
yes, my lord,
thinking that the plea of alibi is a question of fact to be proved in the trial. That's the reason.
This is not written there in the cognizance order. Simply
written.
I filed some citation, keep it to some of the lordship. So for this, whether cognizance can be taken or not at this juncture, lordship, because this is a legal document. This document is a legal document. It's produced by the police. Which this concern, lordship.
So these are the facts to be established in the trial. It has to be
correct, lordship. If your lordship, I am not a present, why should I go for first trial, lordship? If the material is not there again,
the 482 court at this stage will see the CCTV footage and pass an order for acquittal.
Your lordship should not be. That has been already verified by the investigation. That has been verified by the investigation agency. They are not given finding, your lordship.
Investigating agency filing charge sheet is not conclusive.
That's true, your lordship. That's true, your lordship. Because my submission got, your lordship.
You are only plea of alibi, which needs to be
that has not been created by myself, but other it has been part and parcel.
I don't think you have a case.
Some of the drive filed by some citations.
You argue on this point at the stage of framing up.
I'll file some citations.
You have
some citations. I have, your lordship. Or else I should not say, your lordship. I have some citations.
What citation you have?
So for this stage, whether cognizance can be taken by the court or not, your lordship. If I am not a charge sheeted accused, your lordship, and there is a legal material submitted by the investigation agency that yes, I am not in the place of occurrence by the time.
These are first principle. You can't get judgment on this. If the charge sheet is filed,
let us try. Let I try.
The magistrate not is a post office that everything will find.
Your lordship, I will find some citation. I may be given one opportunity, lordship.
I will give, but what is the proposition you want to propound?
So for this part is concerned, lordship.
Magistrate has no jurisdiction to take.
No, your lordship has a jurisdiction. Can I say your lordship no jurisdiction? I have ample jurisdiction to
adjournment, you take it, but you don't have a case.
Any other day,
okay. You take adjournment, no problem.
Yes.
After 2 weeks, sir. If you have some direct judgment according to you, show me.
Yeah, I collect.
Yes. Next.
16 lords, I pray same day by both the courts, lords. Because we are not on bail, lords.
Bail application rejected already?
Yes, well, rejected. First or second order was passed, that has not been complied with.
Then what can I do? I can't sabotage the order of a coordinate bench.
Only a lordship.
Some order, I'll simply say, what is that order you show me?
First or second order with me, lordship. Order has been passed in ABLAPL number.
I can only extend the time.
Yeah, that's
true. If you take the benefit of that.
12763 by 2020.
Show me that order.
The order is not with me, lordship. I'll file on download into the same lordship so that the lordship can pass order.
Just see, show me that order so that I can extend the time to take the benefit of that order.
This number, your lordship.
I pass or get it. Get that.
No, 12763 by 2020.
I need to see the order, copy of the order. Just
supplying your lordship.
Yes, so that I can extend the time so that you can go and
yes.
Next.
My associated supply the same.
24, my lord.
Deal of yours.
Yes.
Yes, your lordship.
Yes.
The IN number 2977 of 24, which is subsequently filed after a filing of a CLMC,
by implementing as a short for to implement the executive magistrate as a necessary party in the particular case CLMC, in presence of whom the matter can be adjudicated. That's why the interim application number 2977 of 2024 height may be allowed. So that
What is
matter
this
be heard
interim?
on merit after executive magistrate against the पक्ष ही ना खाली स्टेशन अफसर पक्ष एक्जिक्यूटिव मैजिस्ट्रेट से जेहेतु से तांकर पक्षरे निहाय दरकार से
Why do implement executive magistrate? Why are you?
Executive magistrate violated the its own order. That's more कहबा कथा. Man, let him finish. Executive magistrate has violated its own order, which was passed on by the year 1995. That a case instituted and subsequently subsection section 144 CRPS 2 subsection 1 of 145 converted, and thereafter the executive magistrate passed order, final and firm order as per subsection 6 of 145 in favor of present petitioner. And subsequently, by the year 2022, that order was passed 9/6/1997, final order, as per under subsection 6 of 145, in disposed of criminal miscase 403 of 2009.
If that order is wrong, you challenge it. I'll just check, see whether the order is wrong or not. Why are you trying to impede the executive magistrate who has passed the order? If that order is wrong, I'll set aside.
Sir,
Show me that order.
Okay. No, more कहबा कथा जेहेतु by
Suppose I'll pass the order, wrong order. Will you impede me in the Supreme Court?
Again, you
have to go to the Supreme Court, say that this order is wrong, but please set aside.
Order challenge dele se पक्ष दरकार नहीं सेटा में
Why are you wasting your time? Show me the order by which you are agreed. Show me the order. Show me the order which is wrong according to you. I'll just see whether this order is correct or wrong.
Annexure 5.
Yes, show me that order. Yes.
At page 60.
Yes.
Annexure 5.
Yes.
Just I'm perusing the order. What order was passed at his behest. By debating everything and while
I think you are not thoroughly prepared. The case you prepare it. I'll list it after 2 weeks. Okay. Prepare properly. Prepare it properly and address, structure your argument, and then I'll hear it. So, after 2 weeks. Yes.
Sir, do it to 1 week up.
Okay, 1 week.
1 week.
Yes. But prepare properly. Don't waste time. Okay. Yes.
37.
Yes, 37.
The FIR is at page 9.
What is he asking? What is he asking for?
The prayer is that there has been a subsequent settlement between the informant, that is the OP number 2.
Investigation is going on.
Yes, sir.
Yes, Your Lordship. My Lord, item 44, Your Lordship. May I please, Your Lordship?
This is 44?
37.
1 minute, 37.
My Lord, I am extremely sorry.
Yes. Investigation is still going on.
Yes.
Yes.
Spending in the court. Yes, Your Lordship.
Yes.
Investigation is on.
Yes.
Page 3, para 3.
Page 3?
Para 3.
Yes.
Paragraph.
Yes.
The dispute of the parties has already been settled in the presence of village.
What are the offences?
Lordship, offences are under section 1 BNS 126(2), that is wrongful dismissal.
Non-appears for the petitioner, even if it's certain call, in the interest of justice, adjourn the matter to February. Yes, next.
44.
May it please, Your Lordship. My
Yes.
Lord, item 44, Your Lordship. There is allegation, Your Lordship. May kindly see one 19 years girl. She is lodging an FIR, alleging that 3 years before she has been sexually harassed. I am not going to details of the matter. That is a matter of investigation and further. Your Lordship, in the meantime, there is a settlement. Your Lordship may kindly see annexure 1 page 37. In the village, it is settled that since both parties are related to each other.
Have you gone through the recent judgment of Supreme Court?
My lord, I bow down, my lord. I do admit.
How will you get over that judgment?
I have gone through the recent judgment passed by your lordship also.
As per my judgment, you are covered.
My prayer is that, your lordship. My prayer
Now the
is that
regime may change.
it is a matter of lives of both the parties, your lordship.
That's right. Everything is all right. But you tell me, how will you get over that judgment of Supreme Court? Recent judgment.
My lord, I do admit, my lord, there are certain obstacles.
I can't help you. That's the problem. You read that judgment and tell me which part of the judgment can help you.
No, I have gone through, my lord.
Or any other contrary judgment of Supreme Court.
So far, the settlement is concerned, my lord.
Yes, in POXO case.
My lord, in POXO matters, my lord, I do admit, but your lordship has very recently passed a judgment in my case that even if the girl is 17 years old, there is a settlement that she would get married after 18.
Judgment I pass on the basis of my own judgment in Rosalind. Okay.
In Rosalind, yes, your lordship.
Now after that, recently 15 days or Ramjilal judgment of Supreme Court.
My lord,
you know.
I, your lordship, respectfully submit.
You read the judgment.
My lord, had the girl, in this case, your lordship, there is some difficulty. Had the girl been of 18 years, below 18 years age, I would not have said anything, my lord. Your lordship may kindly see in the FIR first line, page 14. She is saying that I am 19. She is in marriageable age. If there is a settlement, if I will be arrested, my lord, nothing will happen.
POXO is invoked, section 6.
But
POXO.
that is 19 years girl saying that 3 years before this has happened.
That's the problem.
This is different, my lord. Had she been of 12, 13 years old.
Therefore, on the facts of this case, try to distinguish the facts of the judgment passed in Supreme Court. They say that once
my prayer is that,
POXO Act, you can't pass at all.
My lord, I do admit, my lord, but in this case, your lordship, since she is 19 years, I pray that let a notice be issued to her, my lord. If she comes and voluntarily says, your lordship will say. If she doesn't agree, your lordship may dismiss my petition. I have nothing to say against this, your lordship. Because your lordship may kindly see the settlement we have made in the family. That is page 37 I am annexing, where both parties have signed. If I am ready to marry, my lord, your lordship may kindly see this will not serve anyone's purpose if I go to jail. That is, she is 19 years.
Mr. Mishra, this will lead us nowhere. The same argument you can't repeat many times will not lead you anywhere, because see, I have already taken a view. That is an exhaustive judgment. I have given the instances also, in which instances the cases will be quashed.
Where there is a I have gone through, my lord. Rosalind's judgment I have gone through.
Sexual exploitation and adolescent love affairs.
Yes, lordship. Yes, lordship.
All these things I have taken care. Yes. But thereafter this judgment, Supreme Court judgment. Please read that judgment and tell me.
Yes.
2 weeks up.
Your lordship, may I make a humble prayer, my lord?
Yes, yes.
Since your lordship is giving me an opportunity, I am obliged, my lord. Your lordship may kindly interimly protect me for 2 weeks only, because I am going to be arrested.
I am not willing to entertain your petition at all because of the Supreme Court judgment.
My lord,
I'll do one thing. The best thing is I'll dismiss it and file, go to Supreme Court and get a stay, showing the judgment, so that at least some judgment will be helpful to others.
My lord, that is not possible on my part. Your lordship may kindly adjourn it to.
What can I do? Supreme Court
in the face of it. My lord, I'll verify your lordship's judgment that I have gone through Rosalind's case, the Supreme Court judgment also.
And try and find out some way out.
Yes,
so
only your lordship may even call it next week. Only for 5 days I may be given interim protection.
Next week.
Because the police is going to arrest me.
Next week. Yes.
That your lordship may say that within 5 days I may not be arrested. Any 5 days only, I will not be arrested.
Now, what is the stage of the trial?
This is no trial, my lord. This is FIR. Investigation is going on. Even not charge sheet.
Investigation is going on, then there is no question.
I am going to be arrested, my lord. The police is after me. I am going to be arrested. Only 5 days I may be given to stay.
438. For that 438.
Your lordship may call it on 25th. Your lordship, I have no objection.
Whatever date you say, I'll call it, but no, I can't exercise 438. In a 482 petition.
No, my lord, only 3
482 petition,
my lord.
I am not inclined to entertain. How can I give a relief under 438?
No, my lord, only 3 days, no coercive action may be taken. That is the
that's not fair. That's not fair. Yes, next.
My lord, shall I call it on 25th, my lord?
Yes, yes. 25th, okay. Yes. Yes. Just I'll run through, then I'll take. Just I'll run through. Yes. Yes, madam.
Section 496, 415, section 2.
Yes, yes. What do you want? Quashing.
Why? They want to quit the. Now
What-
they are saying.
What are the offenses?
226,
Tell me the old provisions here.
51.
Madam, tell me the allegations. Don't say the sections. Tell her the allegations. What are the allegations against you? Parties are there? Yes. 115. Yes, madam, you please tell me what are the allegations?
Keep illegal relation with another lady and torture her physically and mentally.
Huh?
Her husband keep illegal relation with other lady and torture her physically and mentally.
That's the only allegation.
Yes, only the FIR has been.
What is 351.3? 351.3? It is new act you have to.
Yes, BNS law.
Just see 351. 351. Oh, okay. Yes. Where is the affidavit? Have you filed any affidavit? At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. The allegation against the petitioner is the page. कुछ भी नहीं दिखता है allegation against the petitioner the investigation in the present case is still going on at this stage. The parties have settled the issue. The petitioner and the opposite party number 2 are present in the court, being represented by their respective counsel and identified by them. They've also filed the self-petition copy of their Aadhaar card to establish their identity, which are taken under account. The opposite party number 2 has filed an affidavit dated 21/11/2024 in Australia, stating and what kind of affidavit you are filing? You are saying nothing. In the petition also you have said nothing. It's horrible. Simply, dispute has been settled, plus. 3, 4, and 5. They are staying together. Yes. On query from the court, just keep it. The query from the court, the opposite party number 2 has stated, but she has, they have resumed their conjugal life, and she doesn't have any grievance against the petitioner. Mrs. Maharana, appearing for the state, submits that the dispute is arising out of a matrimonial code, and the parties have settled their dispute and filed a affidavit before this court. Since the parties have already settled the dispute, there is no legal impediment in quashing the FIR. Regarding the fact that the dispute is arising out of the matrimonial misunderstanding, and the parties have settled their dispute and resumed the resumed their conjugal life. Regarding the judgment of both the Honorable Supreme Court in Gyan Singh, Madhav Rao, and P.H. Joshi, subjecting the petitioner to the rigors of trial would be a futile exercise. Therefore, the petition deserves merit. Accordingly, the FIR and consequential proceeding arising therefrom, who are the present petitioner first. Yes, next.
Yes, your Aadhaar card and
Aadhaar card, give the Aadhaar card.
आणि से कोण पुलिस पकड़ छाड़ दिया सुन चेक
Yes.
46.
Yes. 46.
Very clear.
Yes,
And the order of restriction passed by the trial court. But I think when we dispose of this application directly to the medical application by the citizen, so that it can be considered. Because no questionnaire was filed and the questionnaire which was filed not in consonance with the.
You are 301 application, PW1, PW9. 311, PW1, who is PW1?
Informant.
Informant, right? PW1, 9.
PW1 and 9.
No, what are your.
File a better application there, because I don't raise any state.
Right. Although the petitioner has challenged the order dated 7/11/2024 passed by learned additional sessions judge Kandamal in ST case number 21 of 2011, whereby his application under section 311 CRPC for recalling PW 1 and 9 has been rejected. But Mr. Dhol, Senior Counsel, seeks to withdraw this petition, doesn't want to press the same with a liberty to move a fresh application before the trial court for the same cause. Accordingly, the present petition is disposed of with the liberty to the petitioner to move a fresh application under section 311 CRPC with better particulars. If such application is moved, the same shall be considered in accordance with the law. Yes, FS, yes.
47.
Yes, 47.
Now,
When you got the mail? No, you tell me the mail date. 23. And NBW issued on 13.
It's not plain and simple like that. So that's why I get prosecutor. And there the affidavit was filed by the victim saying that the petition was married. And while granting bail, there was an observation in page 10 that the accused petitioner and the victim informant have to file the marriage certificate within particular days.
Yes.
That will not be compliant. Marriage will not be materialized. Application for cancellation was filed. That was rejected by the court below.
And NBW issued.
Then the victim moved reasonable court under Annex 2. And in fact, reasonable court cancelled it saying that you should surrender and there are to be validity legal consideration. And post after that, the warrant has been issued. That is good.
Go and appear.
That is
Go and appear and resort to the remedy available to you under law. I will not say anything. I will simply keep the execution of NBW in abeyance till a particular date and allow you to go and appear before the court and resort to the remedy available under law. That's all. Beyond that, I can't do anything. Yeah, right now. Petitioner is agreed by the order dated 13/3/2024 passed by the first additional sessions judge Baripada in ST case number 125 of 2022, whereby NBW has been issued against him. Without adverting to the details without adverting to the merits of the case, suffice is to say that the petitioner shall appear before the court on or before the 15th of December so and so and resort to the remedy available to him under law. Mr. Samir Mishra, senior counsel appearing for the petitioner, submits on instruction that his client is ready and willing to appear before the court and resort to the remedy available to him under law. Regarding head to the statement made by the senior counsel at the bar, the execution of NBW issued by the trial court by the order dated 13/3/2024 in ST case number 125 of 2022 shall be kept in abeyance till 15th of December, subject to the condition that the petitioner shall appear before the court on before 15th of December and resort to remedy available to him. With this observation, the petition is disposed. Yes. 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 29/24. You are on bail.
9/11.
Date.
9/11/2004.
9/11/2004, NBW issued on 2/9/2024, set aside 500 costs. Yes. Next.
Name Belgium matter, NBW issued on 22/7/2024, 205 petition was allowed, thereafter no steps taken, NBW was issued.
Petitioner moved an application under section 205 CRPC, which was rejected by the court below, and issued NBW against the petitioner by the order dated 22/7/2024. 24. He agreed by the same and has filed the present petition for quashing of the said order. On instruction, learned counsel for the petitioner submits that his client would appear before the court on 15th, on or before 15th December, and resort to remedy under law, and quash with 500 cost. Yes.
50. My lord, in this matter, my lord, though the petitioner was appearing most of the time, but requested the trial court to take up the matter and dispose of the matter, because there was a compromise between the parties.
Yes, what
to be decided.
Yes, tell me what happened then.
So he has also issued NBW against one petitioner, whereas the other petitioner there no NBW issue.
Petitioner is agreed by the order dated 16.
Yes, sir. Targeted the matter to dispose of. Only
You have come against instance of NBW, you want some other relief. What is this? I'll cancel the NBW, go and appear. I don't know. Petition is agreed by the order dated. I'm watching it.
Sir.
I don't know. Petition is agreed by the order dated 16/5/2025, 22, whereby NBW against him has been issued. He submits that the petitioner was on bail in this matter, and due to default in appearance on the particular date, no NBW has been issued. On instruction, the learned counsel for the petitioner submits that his client would appear surrender before the court on 15th of December 2024 and resort to the remedy under law. Regard being head to the statement made at the bar, the execution of NBW issued against the petitioner by the order dated 16/5/2024 shall be kept in abeyance, subject to the kept in abeyance till 15th December, subject to the petitioner appearing before the court and paying cost of ₹500 to the bar association. Yes.
My lordship, it is 16/5/2022.
22. Yes, 22. Yes, 22. Yes. Yes.
Bail granted on 24/6/2016. 24/6/2016 bail granted.
NBW 19.
NBW 6/3/2019.
Okay. Pay it 1,000.
Yes.
1,000. Yes.
52.
NBW issued on 12/9/24. You are on bail.
Yes.
Yes. Date. Don't know.
2/4/2019.
2/4/2019. Okay. 500. Yes. Next. Compromise. And let them say nobody is there. Huh? Who? Your matter is there. 105. 103. 103. Settlement matter. Okay. What is the offense?
The lordship, the offenses are 498, 377, 223, 506, 343, 292.
Yes.
The last occasion, the lordship had directed for
323. Okay. 4 private. Yes. All the accused persons are here.
Yes.
Bibu Prasad, Chittaranjan, Balaram Das, what is Balaram? Monolata Das, Chinmay Ranjan, and Sunita,
He's the
informant. Where is he?
document said that the
Madam, settlement matter, the informant has to come.
she has already taken the alimony, your lordship, document, see page number 29.
Notice was issued or not?
Yes, your lordship.
Service is complete. Let's Where is the degree of divorce?
Actual series, page number 78, starts from page number 17.
Service complete. Service complete. Service complete. Just see, madam.
Yes, madam. Page number 17. There is a degree of the divorce number.
Where is the affidavit filed before the, where is that?
Page number 27 starts from page 27. The relevant part is at page 29, paragraph 13.
Right on. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. The allegation against the petitioners are agent. Okay. The notice was issued to the opposite party number 2 by order dated 28/10/2024. The service for the notice is sufficient as per the report, SR report. The matter was again taken up on 19/11/2024. However, none appears for the opposite party number 2. Then counsel for the petitioner has taken me to the proceeding initiated by the petitioner number 1 against the opposite party number 2 before the court of family judge Cuttack in civil proceeding number 393 of 2019 under section 13(1)(1)(a) of Hindu Marriage Act. The parties have settled the dispute and filed joint, what is it, 27, huh?
Yes.
Joint petition before the family court Cuttack, inter alia stating as under. Inter alia stating as under. Which is the relevant part?
Page 29, paragraph 13.
Yes. Inter alia stating as under. Para 13. Inter alia enumerating all the settlement terms, including the following term. 30, para 30. Relying upon the said settlement term, the petitioners have now approached this court seeking quashing of the FIR and consequential proceeding arising therefrom. Since after notice, the opposite party number 2 has not appeared. It appears that she is no more interested in the present proceeding. Even otherwise, she has already committed before the trial court in the civil proceeding that after the settlement she would cooperate in quashing the FIR registered by her against the petitioner. From the family judge Cuttack, by its detailed judgment dated 25/3/2022, has already dissolved the marriage between petitioner number 1 and opposite party number 2, inter alia stating that the petitioner has already inter alia stating as under para 6 and 7 of the judgment. Para 6 and 7. Regarding head to the aforementioned, I am inclined to allow this petition. Even otherwise, on the facts of the present case, subjecting the petitioners to the rigors of the trial would be a futile exercise. Hence, the case of the petitioners are directly covered by the judgment of the Honorable Supreme Court in Gansing and so on so. In view of the aforementioned, the FIR number so and so and consequential proceeding arising therefrom, the present petitions are passed. Yes. Yes. 53. Yes. Yes, Mr. Jana. Got it. You have.
CD has not come, my lord.
Get the CD.
Given some deposition.
Get the CD. Yes. Yes. Next. Okay. Oh, let him get the CD. Yes. Next.
54.
Deposition. CD is not required. Read the deposition and tell me. Yes.
I am ready.
Yes. Let him go through. Let him go through. Yes. Next.
54 376 AB is there, my lord. 376 AB is there. So notice is to go to the information.
This is
notice is to go, my lord. One is the offensive.
This notice to opposite party number 2, written after 2 weeks. Yes. Next.
Lordship, here the offence is 457 380. Subsequently, it turned to 392 IPC. And on the last occasion, Honorable Court called for the up-to-date case diary.
Yes, Mr. Jana, you have.
No, my criteria is not, but he is identified in the TI period.
No, sorry.
Criteria is not there, but he was identified in the TI period.
Yes.
Lordship. Lordship, here the offences is 457 380. Only 392 IPC. Allegation against the present petitioner is that some unknown person entered inside the house of the complainant and took away some gold ornaments and some cash rupees. And
you have been identified.
I have been identified. In between this period, charge sheet is submitted.
Material witnesses. How many material witnesses?
It is not come. That is the my lord.
Charge sheet is Lordship. Charge sheet is submitted, Lordship. And I have been forwarded on 2/5/2024, Lordship.
Identifying witness led, identifying a witness examined, thereafter if he will not support them.
You tell me how many eyewitnesses?
The CD is not there.
Material witnesses also you don't know.
The CD ta nahi.
Call for CD. Okay, call for CD. Yes.
56.
Call for CD. Yes.
Matter, my lord. Several antecedents are there against the petitioner matter. 27, 21, like this matter. Let them file a complaint. I would copy them. We have to take instruction from the IO. I would copy them. I would instruction now.
Give the next week. Yes.
57 is same connected to 57 is also connected to the 56 also.
56. Give the affidavit. Give the affidavit. Let him verify all. Yes. 57 also. 58.
May I please, Lordship? Lordship, on the last occasion, what happened? Honorable Court directed me to file an affidavit before the Honorable Court. I have filed that affidavit regarding the criminal antecedent of the present petition.
Affidavit filed, verified.
In this case, what happened? Though I have CD, lots of copy of the bail petition is not with me, and so also affidavit filed by the my learned friend is saying that it is filed.
No, why don't you supply the affidavit to the prosecutor?
Lordship, I have the copy where they have received that copy. It is specifically mentioned, Lordship.
Where have you served them?
Lordship, through e-courts service. Here, what happened, Lordship? Collector got a staff.
Verified. Once again, just contact and take it. Yes. After 1 or 2 weeks. Yes. Next. Yes. Yes.
So, the matter is,
59.
I'm seeking review of the judgment passed by this honorable court in RSA number 90 of 2011.
Yes.
For judgment dated 21 January 2008.
Yes. Come to the point. What is the error?
What has happened? There is no error as such.
Then why review?
I'm explaining that back. In this case, what has happened? The entire litigation revolved around the judgment.
Don't argue the matter in the extent so. It is a judgment passed in an RSA. You have filed a review petition. You tell me under order 47 whether the case falls or not. Apparent error on the face of record or not. If you have, tell me, otherwise I'll dismiss.
The other point is that there are some
other points will not be considered in this proceeding.
There is section
you WhatsApp everything and taking out mobile now. Yes. Order 47.
From the discovery of new and important matter evidence, which after the exercise of due diligence was not within his.
Which document show me? If you are relying upon that clause. Which document? No, show me which document you have discovered. And when discovered, you show me the review petition. If it was in existence, you have not placed it before the RSA court, then you have no case. If yes, annexure, yes, 2, yes,
Annexure 5 and annexure 6.
yes,
And annexure 7.
yes, yes. You applied, you got these documents on by applying in RTA, yeah? 15/3/2022 for the judgment.
Judgment is dated 21st January 2022.
15/3. Show me in the review petition when you came to know regarding the existence of these documents. Show me. After the judgment was passed, you move an application in RTI and obtain those documents. Now you are filing review. And show me from your review petition that you came to know about the existence of this document. When?
Lordship, actually, when this matter was disposed of by this honorable court and I received this brief, I only suggested the petitioner to apply. And my lords, even if my lords, that part is my lordship.
Then you don't have a case, simple.
I have, my lords, can give a glance to annexure 7 because that is the latest document which could not have been applied before. In this case, what has happened, my lord, this opposite party, during the pendency of this second appeal, can give a glance to page number 50.
Yes.
This is the legal ad certificate, my lord.
Yes.
Now, my lord, this legal ad certificate clearly shows that he is claiming to be the legal ad of Biswal Kalyan.
Yes.
Whereas the entire case is that he is saying that I have been adopted under the Kutia Convention.
So this document was in existence since 2021.
My lord.
16/6/2021.
Yet the applicant is the opposite party himself. When you are claiming your entire case lies that you have been adopted, you are now son of someone else.
Why have you not relied upon this document at the time of RSA or have you moved application under Order 43?
No,
to read evidence. Then what case you have? Nothing. Nothing. I can't rely upon a document. If a document you have discovered subsequently, you have specifically pleaded this document was though in existence, but it was not known to me. I came to know this about this document after the judgment is passed. Then I can think of doing something. Where is your requirement in the review petition? You move application RTI. That's what you have said. I have read it.
These are their documents were there because of maybe he may not proper guidance or suggestion was not given to the petitioner. He was not able
The truth is very harsh to you. What to do?
These are my lords glaring, my lords.
Yeah, I know that clearing, but what to do?
Things that
Review jurisdiction is very
limited. I understand, my lords, but
saying that improve your
some wise advice is coming for you. Just I simply adjourn it. He is advising something for your benefit. I'm simply adjourning it. Okay. See, these are very small technicality. You must learn things from right people. Yes. I'll simply adjourn. I'll not say anything. Okay. After 3 weeks, huh? Yes. You have to very specifically say existence of document when you acquire the knowledge. You have to say that this, though the document might be existent somewhere, but I came to know about this document after the judgment was passed. So I could not lay hand for XYZ reason, whatever. Then you may have a case, then we can think of doing something. Okay? Right. Yes.
Just be kind.
Yes.
Court is just being kind and you must learn from this.
That's how they learn. Yes. Yes.
And 16 extension of time of surrender. The lordship is here suffering from kidney disease and the lordship was.
Where is the application?
I find 1466.
Yes. How much time do you need? I'll extend. Kidney patient, why? 1 month, huh? Right on. For the reasons stated in the application, the interim bail granted to the petitioner. But this is last extension. You get yourself treated. Not that once interim bail, then you keep on.
6 weeks. 6 weeks.
Okay, 6 weeks. Right. For the reasons stated in the application, the interim bail granted to the petitioner by the order dated.
And order dated by the third.
28/10/2024 by this court is extended for another period of 6 weeks, and it's made clear that no further extensions are granted. Yes.
61.
Yes.
I prefer adjournment. I prefer adjournment. I prefer adjournment.
There is a stay? No.
No interim order either.
Addressing left without instruction.
Press notice. Take out fresh notice. Opposite party. Fresh notice. Yes. Opposite party notice. Yes.
62.
Yes.
No such addressing.
Notice on the opposite party number 2 is not sufficient. The petitioner is directed to take fresh steps to serve opposite party number 2. None appears. None appears for the petitioner. In the last date appearing also, nobody appeared for the petition. No. Last date also nobody appeared. None appears for the petitioner. On the last date of hearing, that is on 27/9/2024, also nobody appeared for the petitioner. Mr. H.S. Mishra, you are sitting here, right here. Yet he is there. Mr. Mishra, is this 69 item? Yes, in the last date of hearing, nobody appeared on your.
Notice sufficient.
I was just dismissing.
Your Lordship may record notice sufficient and.
No, notice is not sufficient.
I think it is sufficient when it was sent through court or something.
Let's see, check it out.
Or it has to be sent by the state because they know where he is posted.
Notice sent to the opposite party number 2 to the ordinary through ordinary process.
Because it is going on transfer plus
steps to be taken for the serving
DG police so that it can, he will know the whereabouts.
In addition, the IO of the case,
My lord.
IO of the case is also directed to serve notice on opposite party number 2, lease the matter. Yes.
64.
Interim order to continue.
Interim order to continue. Yes. Yes.
Further, my Lord Director, to produce the charge sheet of the case minute.
Yes.
I had to apply for the verified copy minute and I produced it today. Copy of the memo.
Sir, you have to file it because
Copy of the petition.
which supply the copy and file it in the registry.
Which petition? The PMLA?
Yes, that is it. Yes. Then counsel for the petitioner seeks 1 week time to file the additional document to substantiate his case. 1 week time is granted to the petitioner to file the document, lease the matter. Yes. Yes.
65.
Withdrawn. Yes. Withdrawn.
6. Actually, in error, if the Lordship sees 65, and noting that the signature of the petitioner is not matched.
What do you want?
We have to be informed in the document party number 2.
It's all right. He wants to withdraw the petition. Let it be. Yes. Next.
Affidavit which he has annexed. So withdrawal not an issue. But if that withdrawal has been done because of the affidavit which we have filed that the matter is settled, that's not an issue because the matter is not settled.
Let the consequence follow. I don't know. He's 80. His petition he wants to withdraw. Let him withdraw. We'll see. Yes.
66.
Yes. 66.
66. Courtmaster was saying, my lord, that the tracking before. I was confused.
Awaiting service.
No, then he told you Neither AD nor unused notice returned from the solo.
Yes, it is gone, let it come.
Tracking report also must be saying something.
That's what it says. It hasn't come. Report hasn't come. Awaiting service, huh? Awaiting service.
So that
fine.
mediation, that's the issue. Because the
Just see.
item bag,
Huh?
item bag, sir.
Not, item has come back.
Item bag, not this. So
Oh, it's a bag, okay, bag. Wait, next week, next week. Servicing you. Yes.
6 week after, sir.
Huh?
Week up, to be on the safe side.
Yes, yes, week after. Yes.
67.
Yes, sir.
This case resonates me out. Law is signed in marriage and the prisoner they loved and got married and now they said it's child law. And so my submission, the FIR and the consequential proceeding will pass. The informant I met, the informant is the uncle of the.
Who are, where are they?
They're staying together.
They have to come to the court.
Yes, both of them come.
And just issue notice. Yes. Issue notice.
Uncle, informant is the uncle.
Yes, issue notice to opposite party number 2. Returnable. Yes.
And for that, in their case, may start because the prisoner, the husband is staying in at our place. Because their case may be
final charge sheet filed in this.
Final charge sheet.
What the offense is?
Offense is 363 because FIR is registered 363 and charge sheet has not been filed.
Lordship, in the FIR it is mentioned that she is a 9th standard student, right? In the FIR it is mentioned.
Oh, now
what is age?
But at that time,
At that time, in
charge sheet you have filed.
Yes.
Charge sheet
Actually, has not been filed.
363.
363. Good. Now, that certificate I filed with the blessed child will.
It's not with us. It's not on record.
No, the notice may go to the uncle, the informant.
The problem is if I'll issue notice by the time they'll file charge sheet invoking POXO, then you are out. I'll not quash it. Maybe follow what I'm saying.
Yes, yes.
Now you are at 363 stage.
Yes, that 360 stage.
You allow them to investigate and file the charge sheet.
Then
they invoke POXO. Then because of the Supreme Court judgment, you are out. I'll not quash. So at this stage only, it is better that whatever I do and do it. Finish it up.
Because both the.
What do you say?
Yes, sir.
Where are they? Where are they?
They have not, but you are someone else up here.
You bring them tomorrow.
Yes.
Otherwise, you will be in deep trouble, I tell you. They'll file a charge sheet invoking 3, 9, see, the girl is, they say 9th class girl.
Next week because
the informant, no, the informant is the mamu of the victim girl. Just specifically stated that she is a 9th standard student. Just stated in the FIR.
Get the girl also.
Yes.
Get the girl. The girl has to be here.
Yes, yes.
Girl, boy, and next week. Huh?
Next week date, so that
date is
date
27. Yes.
Oblate.
68.
Tell the IO not to file the charge sheet. Tell the IO, telephone and tell him that don't file the charge sheet. Yes. Next, press notice. Yeah. Awaiting service, huh? Awaiting service. Okay. Yes. Entry mode continue. Yes.
69.
Yes.
It's not filed. It's for service notice not filed.
Entry mode of nine. Refugees notice was not issued. Issued.
It is not filed.
Notice was issued.
Notice was not issued.
Where is the refugee?
Refugees for expensive notice not filed.
Why I have not issued notice? Press matrix here. Have I issued notice? The proceeding upload कहीं करना भाई upload कहीं क्यों proceeding?
So mistake must be.
My lord, I am challenging the complaint case filed by the complainant, which arises out of a NI Act, Equitable Instrument Act. My lord, the complainant only to avoid to receive the rupees 8 lakhs, which has been borrowed from me on 15/11/2021. Only for that, when I am demanding that money to be returned immediately to me, he has also manufactured document, filed this complaint case against him. Only they let the notice go, let him appear.
No, no, it's 138 NI.
Again.
You have issued the check.
Yes, I have issued
Then?
the check. They have treated that document. I have not issued any check, nothing. Because nothing due or me that I issued the check.
Just see your petition. What have you written?
No, that was the complaint petition. That was the complaint petition I have also stated. But only to avoid that my dues, that is rupees 8 lakhs they have taken. 15.
You just simply tell me whether you have issued check or not.
No, I have not issued. They have prepared that.
And show me your reply to the statutory notice under 138 NI. Have you taken that stand?
Yes, sir.
Where is that?
That I have not done it.
Then? This is the first document you should have annexed. Nothing is there.
We will take care of all the capture and I will study, sir.
Why are you filing, wasting your time? Court's time. See the petition, what have you written? And you have not filed even any document also. Only one complaint copy, that's all. Watch it. 138 cases, the statutory requirement is within 6 months it has to be completed. And when this case was initiated, Jesse? It's 6 months. This was filed on date is not the yes, August 2024. What is this says? What is this says?
No, notice has been issued as yet.
Then?
Only to take
No. It's the petition is bereft of any particulars without any document. Learned counsel for the petition seeks to withdraw this petition to file a better one, a better petition. With this liberty, the petition is disposed of. Yes. And file, see, write something, some particular, what is the stage when the notice was issued, nothing is there. Yes.
72.
Yes, 72. Yes, Mr. Vigyan Sharma mentioned it. In the connected matter, he is not prepared, so he asked for an accommodation.
His client demanded, Vigyan Sharma's client received, and he had taken.
He has moved an application for stay of conviction. Therefore, I am giving priority to this matter. List it in the supplementary list only, it will come. I'll hear it. Yes. Yes.
72.
72.
72 will come along with 1069.
1069. Appeal.
CRLA 1069 of 2024. When it was admitted
weekly. Along with so and so, weekly. Yes.
1069 of 2024.
Weekly. Next.
74.
My plea. Yesterday, your lordship that last time observed that the CRLC 1703 of 2023, I will hear that splitting of the case.
Yes.
Blood.
What is this case?
This is a case relating to the allegation is that we have taken compensation as Garbhari, whereas it is earned mama without any basis.
You are seeking quashing.
In
this petition, you are seeking quashing.
Now, this is against the order splitting the trial against the land acquisition officer who did everything in accordance with law. And mechanically, he is also been added, but he is not appearing. And there are my last friend very casually said, what is wrong in the new order 317? There is enough of wrong orders.
Yes.
I have found a detailed note.
This is the
Madras High Court. If your lordship will say, I will give it.
Yes, yes. Where is that order?
My lord, the order is paid 10. It's a triptych order without the state will say a government servant is not available. Warrant is not executed. 82, 83 is not resorted to pursue. This is what thereafter other matters I will say.
No, show me the imbue order.
Yes, but page 10, my lord.
Page 10.
Page 10 of 1703 of 2023.
1723.
Sorry, 1703 of 2023. CRLNC.
That matter is not listed today.
The last, yesterday, no, please. Yesterday when I made a mention, your lordship said I will hear it tomorrow.
No, that I have kept it reserved. I thought, I said, or the other matter I'll hear.
No, this matter also.
No, that matter I heard, I understood it.
I will put the judgment here, the matter, though very lightly said, there is a detailed judgment what is to be done before directing splitting. And also very great article has been published also.
Show me that judgment.
Lord, this is my lord. The Madras High Court in the case of H.
Give me a copy of that.
Lord, I was trying to get it through the online, but I could not get it online from the bar. Neither in my house nor I could get it. Yesterday night
Shall I release it after a week?
But that is the reason that, Lord, first of all, I came here to challenge the affair. Thereafter, the charge was framed, that is challenging.
Don't tell all this. You concentrate on, you just argue this 3359.
Madam.
3359. What is this? 3359 or 2012?
3359, your lordship kindly see.
Yes. How are you agreed by?
Your lordship kindly see the order dated 6/11/2012. As back as in 2012, it was
6. Page number?
It was 6/11/2012.
Which page?
Order passed by your lordship.
Okay, my 6.
Soon after my filing.
6/11, huh?
Yes.
Yes.
Directed to produce documents seizure list received from the office of the special land officer. They have not yet produced till today, even though 12 years have passed. And this vital document, Lord, my land is there. That time.
Now, when the charge sheet was filed?
When it was taken.
Charge sheet was filed on 8/5/2015.
See, you are relying upon the interim order passed by this court on 6/11/2012. That time the direction was made to produce the seizure list and of the other documents.
To him.
To him. And subsequent thereafter on 2015, charge sheet has been filed. In the charge sheet, you might have got everything. All seizure list, everything would be there in the charge sheet.
It is not there.
Obviously, in the charge sheet, that would be there.
It is not there. Your lordship can say, let them produce. It is direction that let them produce.
Have you placed the charge sheet on top?
No.
Charge sheet copy, you might have got it.
Who?
You?
Yes, yes, might have, but
There, see.
they have to produce. What happened, my lord? Your lordship can see. Initially, I filed this petition 3359 for passing of the affair. Because there is absolutely no offense is made out against.
Yes, concentrate in there.
Yes.
And let us see.
Yes.
Yes, any case made out or not. If it's not made out, I'll quash it. Simple.
So, yes.
Yes.
If it is called, then everything goes.
Yes. Show me.
Well, your lordship can see, they have not filed, they have not chosen to file a reply to this. I have given entire the certified copy, the document, and before my lord here, another complaint was made against me to the revenue department. Your lordship can see, page 5, paragraph 11.
Yes.
Nothing has been controverted, and rather that one overzealous person named Upendra Kumar Sahu even made a report to the government regarding payment of compensation to the petitioner. On receiving the said complaint, the Joint Secretary to Government Department of Water Resources, Orissa issued notice to the petitioner to inquire about the matter and found that the plots in question which were converted to Garbari has been found to be the fact.
This is your contention.
Yes, based on record, Annex 5 is the notice I have received.
Yes.
It is a government record.
Yes.
They found it. And with some ulterior motive, without, here he is a man who has donated a lot of money for school and college. The father of the president, and all are educated, serving somewhere else. They applied for conversion of some patch. They have got around more than 30 acres. Out of 30, around 12 or 15 acres is on within the both sides of the road. Now it is national highway. At that time, it was state highway. And it is converted in accordance with law. That is why the Honorable Court on my submission directed to producing that will cease.
Yes.
Whatever you see that on the basis of what you have made out the case that is not converted to Garbari, and they have given taken a compensation for Garbari. So that is why thereafter this government not inquired and annexure 5 your lordship kindly see the notice issued to me.
Yes.
These are all uncontroverted statement.
Yes. You file the copy of charge sheet.
Renowned scientist.
Do you have a copy of charge sheet?
Yes.
You place it on record. Because he had. Huh? Where is that?
In Sierra Leone, in the Sierra Leone.
What is that?
They are silence for reinvestigation.
No, that is for because.
No, the first matter he is seeking quashing of FIR.
Proceed.
Yes. Second matter.
They have challenged reinvestigation. That's
Challenge
for reinvestigation.
Yes.
Then another that is.
I filed a petition to discharge that is rejected against that order I have filed.
Then another petition that is the rejection of discharge.
Discharge petition. There are 3 petitions.
Yes.
3 petition, another petition challenging splitting.
4 petitions.
In different stages, whether
Yes.
because the moment the moment I stand up.
Then let us hear the last matter first.
No stage. They proceeded.
Let us hear the last matter first then.
Madam.
Last matter first.
Madam.
2023 matter first.
Which one? The
Last one.
The
1728.
No case is better. If your lordship your this document.
In so far as the first matter is concerned, it lost its sanctity in the sense. Subsequent thereto, charge sheet has been filed. You move an application for discharge, which has already been rejected. So the first matter become inconsequential.
Yes.
So let us concentrate on the second matter, discharge one. Let us concentrate.
That is what I say. And my last friend was opposing the filing or filing.
No, you have right to file.
I have to file.
You have right to file. Yes. 2016 matter.
1505.
Yes, 1505. Concentrate on this matter.
Sierra Leone.
Yes. Sierra Leone. Okay.
Sierra Leone.
What is this?
1728 of 23.
23. That is against the charge. Discharge. Yes, that's what I was telling.
1728.
1728. This is the last matter first. Okay.
Here, my lord.
Yes.
Your lordship can see the impugn order.
Yes.
Please to allow pass the impugn order an extra 10.
10. Okay. Come to 10. Yes.
Fine. I filed a petition to discharge an extra 9.
Yes.
The law was set into motion on the strength of the first information report lodged by Sri R.L. Patra, Inspector Vigilance, Balangi, such and such. 1910-12, and the said report was registered supplement vigilance case number such and such under section 13(2), read section 13(1) C.D. of the PCS. Read section 420 and 122 of the IPC. That after registration, the Representative Inspector R.L. Patra, Vigilance, Balangi investigated the case, submitted charge sheet against the accused persons under section such and such. Against Sri Vinay Kumar Karnak, ex-special LO, who is now absconding. As Balangi, Sri Indresh Hassanab, special LO, Balangi, Sri Ramesh Chandra Mishra, retired RA, Joy Krishna Behera, Anand Chandra Behera, Bharat Kumar Behera, Dilip Kumar Behera, and Akshay Kumar Behera. They are the petitioners, who are sons of late Venudhar Behera of the village Bakal. The present petition is being filed on behalf of the sons of the late Venudhar Behera. During pendency of the case, Dilip Behera has died. That in order to acquire land, village Chudapalli of the North Suktel irrigation project, an area of 476,190 districts of village were being processed after notification of section 4(1) of the LA on 29/12/2003, which was served upon the villagers of Chudapalli on 10/6/2004, and declaration under section 7 of the LA was issued on 24/11/2006. And process of awarding compensation under section 11 was passed by special LO on 28/12/2006. That it is transferred from the police paper that the landed property under holding number 132 Moja Chudapalli was recorded in the name of late Venudhar Behera, was also acquired by the government for the purpose of LSIP. Further, it transferred that the sons of late Venudhar Behera effected division of the property amongst themselves. It is all on record.
Yes.
Before the Tahsildar Balangi and have been issued with a separate portage, whereas the variety of land was changed from Berna Mamali to Gharbari on 19/12/2016. This is not controverted. In response to the notice issued by the special LO, Balangi, all the 5 brothers submitted their representation to pay compensation for acquisition of their lands on the basis of the individual holding issued to them by Tahsildar Balangi, whereupon the special LO initiated missed cases and inquired into the matter, and after file verification passed awards in each of the cases on 23/3/2007 and afterwards observing all legal formalities. That out of the 5 brothers, only Bharat Kumar Behra was disbursed compensation on 29/3/2008 as per the award passed in the miscase number such and such. Because of which the rest of his brothers again submitted the petition before the special LO for payment of compensation and special LO for conducted inquiry and verification physically along with the staff, and finally disbursed compensation amount on 6/1/2010 by following the legal procedure. There is no whisper in the entire prosecution case that the accused person by resorting to any illegal means or by playing fraud have received compensation. As a matter of fact, it is admitted that the property of the accused persons were acquired by the government for the purpose of irrigation project. That the accused persons are being prosecuted only because they have received.
Who is Benugar? Benugar is your
Father of the officer. He had donated a lot of land for school and college in that area. That is they have received compensation amount showing the acquired land. As the person Dilip was that Behra died is a renowned scientist of the state. He's a soon after the retirement died, and his procession was something to be seen.
Yes, Mr. Mahana, what is the material?
No problem.
See, Benugar is the original owner. He had 5 children, and they are the LRs. And land is acquired, and proportionately the compensation is paid to them.
No, that is not. That is not the case.
What is the case? That's what is reflecting.
That's completed or your lordship's query I can answer.
No. Case is that some of this land, if they were divided, they were equal portion. Some of the land, instead of Berna Mamuli, that is converted to Gharwari. But that is the thing, and that is based on record done by the Tahsil office itself, and the certified copies are there. It's all in accordance with the law. So,
for the purpose of getting little more compensation, you have changed it to Gharwari, and that is the allegation. I understand. Yes.
That is without any basis. That is the only.
That's the whole.
That's the whole.
Yes.
And they have not filed any counter also controverting my.
Counter, forget in criminal case. I will not decide on the basis of pleading. Yes.
2007, on the basis of that application and the action for CORAM notification, the compensation was allotted. The land was bono obligation.
What is the rate of compensation you paid for both type of land? You tell me. Section 4 is not disputed. Section 6 is not disputed. Not disputed. Yes.
After 3 years, they managed to create a false document and showing that the land is Kisama of Gharwari.
Which are the false documents?
And mistakes record also. They have tried to manipulate the record of the mistakes on the Tahsil officer to obtain this arrow.
Show me that.
And you will also can see come to that is the page 7 that the charge sheet have given that.
Yes.
Joy Krishna Behra and his brothers who managed to got 72,760 only by means of change of Kisam by their land against the old calculation 7,05,000 some. The ROR stands in the name of Benudhara Behra, the father, late father. Balangi speaks that all the alliance plots, number so and so, in respect of which the compensation was awarded.
Plots are also not disputed. Only the nature of the land is changed. That's all.
Subsequently, changes have been reflected regarding some of the plots to Gharwari by encircling the respective plots with the signature of the deed and Tahsildar.
Show me section 4 and section 6.
What?
Notification under old act. And there is a point why I am asking. Section 4, section 6 notification and the nature of property might have been written there. Let me see that.
That is there. That is not disputed. Your lordship can
show me that.
Your lordship.
Yes.
That is encircling that the conversion they showed that they have obtained the ROR on the basis of a miscase. That is miscase number 234.
Please show me section 6. If at the time of section 6, if the nature of land is already written there in section 6 notification, there is no question of manipulating subsequently thereafter. And if you have made out a case, subsequently they have manipulated. If in section 6 it is reflecting, that's all.
Section 6 reflection.
Show me that. That's what. Where is the notification? Show me the notification. Yes.
Investigation reveals that, first page.
Notification, I am asking notification.
Notification का
Section 6 notification.
notification that is there.
That's the
Not disputed, that is Kishore Bonam, that is the charge sheet. That charge sheet speaks.
I don't believe charge sheet. I want to see the document myself.
Then I
Let me find the reply.
That is the whole case.
the whole case of the prosecution that the miscase they are referring basing upon which the land was converted, that miscase led to another.
Many a time what happens, you know, the IOs right Goda Bekri Goda will Lekonti.
Based on document.
Yes, I want to see that document itself. Yes. You show me that. See, only section 6 notification. Even 4 I don't require. 4 you may not get that. But section 6 notification, notice for taking possession. Section 6 is taking possession notice. In a possession notification, the nature of land might have been written. If nature of land is already written, then under section 30 they will take the compensation. There is no problem. No problem. Is it any reference was made under section 18? Any reference?
The reference is that is I am clear. Thing is that he got compensation without any dispute to the tune of rupees 7 lakhs amount because it was Kishore.
Thereafter 18 was referred.
Thereafter, after to near about 3 years, they manipulated the records by creating a miscase, referring to a miscase of a 2001. Sorry, by support and that miscase on the basis of that miscase, mutation case, that ROR was published, and ROR the signature of the Tahsildar was not the Tahsildar that was also tampered. And the 122 of 2012 the miscase mutation case government conversion that is related to another mujab, another plot and another person.
All these things has been done
That is our case.
All these things has been done after the award.
Getting the compensation.
After the award, then obviously. After the award.
After the first award.
Obviously, first.
That is our case. So basing upon the manipulated document.
Go slow. You say that they have received the compensation. Receive of compensation arises after the award. In the award, what was the nature of land written?
That was written that Bonamamuli initial. The initial award. That was 7,05,000. That was.
Thereafter, they referred section 18.
They are referring to section. They have made a very simple notification. Your lordship, that has been clearly mentioned. The record has been seized and
the compensation increase. How the compensation increase? Under the reference of what?
They made an application and it was taken up same day by the then co-accused. And your lordship kindly see the way that was dead.
Yes. Show me. Show me that.
Chapter 69.
69.
That is where counter is received.
No, counter. I don't believe.
Yes.
Yes. 69. 60?
68. Who takes 2 copies?
I have given the entire record of writing miscase by their own office, and now saying that I have tempered in the office.
68, yes.
On receipt of prayer petition of 5 it was noted that rate of compensation towards land acquisition was 57,575 per acre in case of a Hon'Ble petition of land, and 6 lakhs as per acre in case of a Hon'Ble petition. Then on the receipt of the prayer of the petitioner, 5 bloggers, namely so, that is the mistake the land acquisition officer, the co-accused, initiated miscase number so, respectively, and fixed a common date, 8/3/2007, and directed for appearance of all the 5 petitioners for hearing. During disposal of the miscase, the government had dealt with following points very commonly in all records and orders. He has examined our of a soil 46 times the record in the name of a vendor Padan. That is the new holding as noted here have been derived from the old holding. Soil 46 now stands in the name of Swanso. The area of plot of Swanso. All the above plots are recorded Bonamamuli Kisam and now changed to Bharabari.
Yes, I got.
Then change of Kisam have been made by the Tahsildar Balani in revenue case number 122 of 2001. That your lordship was a moment here. And on the investigation it is found that basic upon which the Bharabari land was that basing there. This record relates to then your lordship kindly come to page 70.
Yes, I'm there.
My lord. But conversion case number 120, third para.
Yes.
120 of 2001, under section 8(1) OLR of the Tahsil Balani revealed that on the petition filed by one Mamata Mahanti, Manoj Kumar Mahanti, for conversion of land by plot number so and so, Khata number so and so, Mouja, Lakipoli. That is in respect of another Mouja, another plot, another person. And from agriculture to non-agricultural case of record was opened by the Tahsildar Balani. After this process, the conversion was allowed and the piece of land was changed from Attam Mamuri to Ghoravai. Conversion case number 122 section Balani clearly indicates that there is absolutely no link with the changes of piece of alleged plots which comes under the Chudapalli Muja. And it is established that some manipulation of records have been done in original Arwa by that.
Yes.
Arwa stands in the name of Benudhara Behra, so and so, maintained in circle Chudapalli, reveals that all the alleged plots, so and so, were only dissolved. But surprisingly, no changes have been reflected in the Arwa regarding changes of petition for those alleged plots. Again, most surprisingly, conversion case number 122 has not been indicated as a change of petition of those plots. Further intimation, slip card number also, also well established that no conversion case was initiated in the 2001 relating to the above noted alleged plots stands in the name of the Governor Pradhan and all. Next part, the Gopinath Das, OS retired ex-Tahsildar Balani during whose information the alleged conversion of the plot had been taken place in the refused to have put his signature on the ROS stands in the name of the judge. So this is the case. On the basis of what your lordship, they have gone to the extent to manipulate the record, court records and produce that record, taken the advantage of record and taken the.
These are entirely baseless, my lord.
Yes.
Your lordship can see from page 46, 160 of that case 1505. I have given the entire charge sheet.
Yes.
Which they have filed. And that is the surmises because the story taken this is beyond this charge sheet. What he is saying, your lordship can again.
Yes.
That your lordship can see the entire charge sheet I have given, which is not there. I have relied on that charge sheet I filed in that 1505. That is why I failed for further investigation of the case. Starting from page 46.
Yes.
The entire charge sheet. You also can go through if there is anything done by me. It is not done by me.
You give me the award and section 6.
And the another thing, my lord, the important thing is all surmises and conjecture. That is not based on this. They have not filed a counter. How can I reply? On the basis of what?
In the criminal case, I don't think counter is required. The documents are enough.
With all respect, my lord. I am placing from the record he has relied.
Yes.
Your lordship kindly page 67 he has raised the CRLMP. He is saying that I am wrong surmiser.
Your lordship can see.
Anyway, now you give me the award copy and the section 6 notification.
Your lordship
That is the basis.
Annexure 4 onwards. Of that 1728. It's a court proceeding. They have converted it.
Yes.
And this is where I have got a role to play.
Let him supply the copy. I understood it.
Your lordship can see.
Parted and reached it after 2 weeks. Mr. Marana is directed to apply the copy of the award pertaining to the present case and section 6 notification. Yes.
We commencing from 16.
This is only for getting the. I'll reserve the judgment then. Let him give the documents.
Here, I think if you will assist your lordship, it will be better clear.
No, you made.
Also, is there annexure 4? I have given the entire charge sheet.
Let him get. I keep it as a parted.
That your lordship had fast order on that to produce everything that what I will see.
No, that is the innocuous order. That is the innocuous order. 2012, when the investigation was going on, that time some order was passed. How does it make sense? Now charge sheet is filed, everything is filed. Forget about it. I will not hear anything else except 1728 of 23. 1728-23 lead matter and the other 2 matters you just tag. That's all.
Yes.
I will not read other matters. Other matters have gone in front.
Annexure 4 onwards, your lordship.
Yes.
Page 33.
Okay, I'll
all miscases
are give it. Huh?
Yes.
Yes.
All miscases are giving the copy where it has been converted by their own authority.
Well, I'll see. Let me see the award first. Award is the basis.
Yes.
Next.
And if they wanted, they could have done the entire land. Why the piecemeal?
Yes.
which is coming under that roadside. That is the only thing. Out of the total, they have not done everything. You also can see what are the land of each brothers that is there from annexure 4 onwards.
The same thing has happened there in Andhra Pradesh in Visakhapatnam. One person named P. Pothirayudu, advocate, and he had manipulated everything. A commission was constituted. He went up to Supreme Court. Supreme Court had passed a judgment on this issue.
Dispute. If you also find it.
And barren land trees were created for the purpose of compensation.
Yes, if you also will say that.
And all these things had happened.
No, that happens. There are many things happen.
So therefore, all these things can be seen from the Section 6 notification and the award.
And what about the
And thereafter, what had happened?
What about the ownership passed by the authority in
I'll see first. Let me see the award.
Yes, sir.
Okay, next 75.
the ownership 16?
And he is going to give a date, adjusting it.
No, the only thing is from 9 to 12, 13, I may be absent beyond that.
9 to
12 or 13, 18, I may be absent.
18.
Yes, sir.
18. Okay.
Well, I may not file petition for. No.
No. 2012 onwards, no interim order. How can I pass the interim order now?
Can I answer this query?
Yes.
The order was passed. The court.
Don't waste time. I will not do it. Yes.
But I am not able to answer the one thing you are also asking from the beginning. I am not able to answer that.
See, 2012,
That is what I
nothing happened. Now, all of a sudden, I heard the matter.
Basis for it. Please hear me for a moment.
I'll reserve the judgment. You file, both of you.
You throw the case. You throw the case. But you please hear me. Please hear me.
What was I doing?
Actually, no. This question, the answer you have not.
Don't try to threaten me. Okay. Don't try to threaten me.
If you are also taking it that way without hearing that.
What way you are addressing the court?
Why should you tell me?
What way you are addressing the court? Is it expected from a person like your standard? I have been hearing you patiently for 2012. Nobody has heard. I am hearing.
With all respect, yesterday you also.
What respect? After disrespecting, what respect?
I have not placed anything. I have not said I have not said anything. You also may pass any order. I don't file.
Why should I file any order? I will pass the order in accordance with the law. What is this? Any order? I will pass the order in accordance with the law. I am going to the root of the matter. I am asking the right document.
I appreciate, but for the interim order, your lordship, from the day one I mentioned, your lordship asking one question. From 2012, how it is going today, again, why you are mentioning?
Yes, of course.
The answer I am giving, and I am not able to give that answer from the day one till today. The whole point is this.
You have been doing it since 2012.
No. Before uttering one word, either he is interfering or something is happening. I am not able to complete my sentence.
Yes, you complete your sentence.
In that case, in the splitting case, interim order was passed. Thereafter, the case was pending, and there was no problem to the accused persons. Even though it was not extended by mistake, inadvertently, 2-3 days it was extended, thereafter it was not extended. And the lower court also did not take anything, it went on going. After 5 things here, the court said that since now what is the position of state, this is the situation, now I cannot wait now. After waiting 5 things.
Well, show me any interim order passed in your case.
Well, that's what is that.
Which?
Yes.
1728.
Yes.
Where is the interim order?
Yes, you also can see that 1703. The whole point is that
1703 is not listed before me.
You are also can see the one.
It's not listed before me today.
Yesterday you also had the order that.
I reserve the judgment. That matter is heard. Reserve the judgment.
I understand. You also can hear me. I will explain the sequence. The sequence always has been explained and it's been heard. It can't be understood.
You tell me you please answer me. 3 matters which are listed today. In these 3 matters, at any point of time, any interim order was there, I will extend it. Simple.
Yes.
Show me.
Please, I am telling. I'm just please hear me for
Yes.
this person. This matter, well, 2 matters were listed yesterday. Well, this matter could not reach. You also was adjourning to some other thing. I let it be. The interim order may be list adjourned. Then I made a mention to your lordship that this matter, the interim order was passed in the 1703. Then your lordship said that I will hear it tomorrow.
Tomorrow these matters.
I thought the 1703 also you will be hard because I made a mention. I said that your lordship has reserved an order. That your lordship said, to my understanding, I may be wrong, that it will be hard today. So in this case, interim order was passed, and this interim order with the trial court continue till today. And when he said that there is no extension order is there, nothing is there, this thing, I cannot wait now. Last 2-3 occasions, they have managed to extend that order.
Yes.
So that is what I made a mention before your lordship 2 weeks back. Then your lordship would be the same thing. It's a case of 2012 or 13, now you are saying so. So all this.
In that matter, insofar as that matter is concerned, I heard you extensively. I have reserved the judgment. Let me pass. You may succeed in that matter also.
With all respect, matter, not extensively. I only said it is splitting, it is not legally. Then your lordship asked the question, vital questions. 82, 83, nothing has been done. Then your lordship closed the matter. It was not the entire thing. So far, the Madras High Court judgment.
Anyway, that matter goes. If that matter goes in your favor, everything will be all in line.
Whole point is that the lordship asks the question. I mean, we may be allowed to.
But in matter which is not listed, you are relying upon that something.
Unless it is calmly it is being allowed to say, the sequence cannot be set in the last 3-4 matters. He said that he was going on filing cases. Your lordship said now that it says just
the sanctity of the proceeding in this court can only be maintained if it is mutual respect. Mutual respect.
Mutual respect.
If somebody takes advantage of his experience and sit over the court, then I don't think
exactly. And mutual
not fair enough.
And mutual hearing.
You command respect because of your age, because of your experience. And all the junior members behind you are looking at you.
I understand.
To learn something. And if you behave like this, junior most probably shouting at
probably 2 years back, just one Justice Waghela.
Forget about the past experiences. Now let us learn to do better in the future.
So, जैसा hearing करते थे, in a criminal appeal we used to argue in before judges like Asif Pandey, BK Behera for 1 day, 2 days.
Sir, those days, how many matters used to be? Today, the pressure.
That is why we say, which can't be said in the court, justice elected, justice buried. This is what we are only. Justice, that ex-Attorney General came in the case of Biju Patnaik, and he said he argued for 2.5 days. That bench did not note down anything. And
I know, sir. You can also match with that ex-Attorney General. You can argue for 1 day. But what is the problem?
Not that 11%.
No, you are, of course. There is no doubt about it.
I have completed only 3 to 4 sentences giving the sequence.
But the problem is, see the pressure.
Your lordship said that this was the old order you cannot do. It was the low. Even though there was no extension, he waited for 6 years.
Anyway, let us not waste further time because people are waiting.
Because against the charge will be different, again it will multiply the proceeding, and my friend will say that he is going on filing petitions.
It's all right, you have right to file, why not?
That's what I say. But multiplicity should be avoided.
Okay, let him get to the right documents and I'll
object to that. And my prayer is only that I may be allowed to, because it is posted 21 for bringing of charge.
I'll pass appropriate order.
Yes.
Please allow me to proceed further.
Yes.
I'll let
one sentence.
103 matters. Yes.
A case was fixed for framing charge. I filed a petition. I was placing that thing. Before placing the impugned order, your lordship shifted questions to him. He rejected my petition to discharge. On that day, he did not frame charge. Ordinarily, what? Petitions should be considered.
Everybody is scared of you, sir. Everybody is scared of you. The trial is also scared of you, it seems. They are not framing charge against you.
My lord, nobody should scared of me. The only one person, if you are scared, I will be.
You are very pleasant.
That is Narendra Modi. If he is scared, then I am happy.
No, you are very pleasant. These are
that. Is all people scared? Lord, I am here. Why should be Satsandar be scared then?
And I'm just jokingly, I'm saying everybody is happy.
I understand. Point is not that. No, dear man, the whole point is that.
Let us not waste time further because the people are waiting.
You are saying what are the cases now? 35 years back, Mr. G.B. Patnaik, who was the retired judge of this High Court, he also said the same thing. Suppose our consumption.
Okay, next 75.
Our consumption.
Let us not waste time because we have wasted about half an hour. Other people are waiting.
Your lordship consider.
I'll consider. I'll definitely. Don't worry, I'll consider. Don't worry.
Only it will multiply the case. Again, you will charge. Again, you will fight.
Okay, don't worry. I'll take.
And they cannot complete the trial.
Yes,
they cannot complete the trial for 2 decades. I can say.
Yes, don't worry. I'll do whatever possible. And don't take it to your heart and yes.
My heart is very strong. I have recently tested it. There is no block and the outward heart is very strong.
Okay, it's next. 75 again. It's all right. This happens.
I don't like this overhearing. The basic fundamental.
Sir, I can't tell because everything is learned from you people.
Your Lordship alone can say, fundamental thing is that when my mouth is open, unless your Lordship interfere, the others should not open their mouth, should not stand up. The whole of standard of practice has gone down. And I told you the word, Justice.
Sir, what happened? See, the junior bar learns from senior bar.
No,
We have to be.
everyone is particular.
No.
We are all particular.
Yes, sir. All right, let us proceed.
Yes. People have the question that
Yes, sir.
fundamental is gone.
Okay, it's all right. No, yes, next. 76. For another.
You make a complete sentence is becoming difficult.
Yes.
Item number 73 now.
Yes.
Petitioner seeks to challenge the initiation of the proceeding and the
Yes.
cognizance spectrum.
You have an interim order, sir.
Yes.
And you have seen how people are struggling to get interim order. Enjoy it. Enjoy it for another 2 weeks. Enjoy it for another 2 weeks. I'll just hear it after. Yes. Wherever very urgent matter, because interim order is there, let me continue. Please sit after. You tell me the date when. Dekhi diyo interim order to continue. Okay.
But this is the present after the storm.
After the storm, always it is calm.
Yes.
Take the advantage of the calmness. Yes.
You are not seeing master, but this I have seen in trial court. I have not never seen in trial court.
I was called bloody my lord in the trial court is not there.
But it is a very high time to improve the standard of the conversation in the court, High Court level. It is getting deteriorated. We have to, uplift the level of, High Court. This is very unpleasant. But what to do? We can't help it. Yes.
77. Complaint case now.
Yes.
Here, my lord, the complaint case was filed on the ground that FIR which I have lost against him ended in final court. For which, but his prestige, his reputation have been damaged. Yes.
What is the offense? 500?
500 of IPC laws, the cognizance stake.
Against my lord, submission of final court, I have approached this honorable court that without issuing notice, the final form have been accepted by the honorable magistrate.
What has he said?
This honorable court.
No, what was the offensive sentence? Huh?
I think.
No, what is the utterances?
Page number 22.
22.
Right.
Come to page 20. Nature of utterances, I guess.
May I permit?
Yes.
The case letter is put up today for necessary order for taking cognizance of that. There is the complaint petition investigation and complaint. Document filed by the complaint. Certified copy of the order dated 4/10/2012. 12 passed passed by the respected CJ SD 1 Qatar in IN number transfer arising out of CS number transfer.
No, what are the allegations? What is the utterances you got insulted?
My lord, because the FIR which one have lodged have ended in final court.
Oh.
That's why my lord, his prestige and his reputation have been damaged. But my lord.
See, he is agreed. Resort to due process. Due process is taken and the final form is filed. Then what is the
Page number 20, my lord.
What is?
May I read your lordship? That is a different matter.
That also.
Leave it here, Mr. Saud, leave it here.
My lord, your lordship may kindly direct this matter to mediation. It is a matter of 500 of IPC. If they say.
Why don't you do it? Tender one line affidavit, I'll close it.
Final form hela.
You are 100% correct.
That policy said that
That is not the matter.
Final form.
Yes.
But the final form which was accepted by the honorable magistrate without issuing notice. That's why now I have approached this honorable.
Who are you? What are you doing, by the way?
So,
Your Lordship,
army of that
Oh. So
Dhara court.
she is the queen, she will not ask for apology.
No, ମୁଁ ସେ ଯୋଉ ଦେଇଥିଲି ଯୋଉଟା FIR ଟା that has already.
That's right.
That's divine.
Then what is the problem? You simply say sorry, finish it up.
Sorry, ମୋ FIR divine ହେଲାନି. FIR ଟା final form ହେଲାନି. ମୋ FIR ଟା divine ହେଲା. How this allegation will sustain?
Merit you may have a case. Yes.
my lord, page number 18, 19, 20. Long statement is there, my lord. It needs time to, your lordship. Your lordship need to hear this matter. Any day.
Interim order is there?
Yes.
Yes.
Continue interim.
If required in mediation process.
Mediation, she is not agreeing.
My lord,
Why don't you try? Interim order will continue. Try. If happens, happens. No. Otherwise. I understand it. See, the basis of the 500 is you file a FIR against me, which is ended up in a filing form. So you have insulted me. Okay, it's all right. But now the FIR is also revived. Revived. Therefore, that basis goes. That basis goes.
but my lord, para number 7 and 8, it is a different, my lord. Para number 7 at page number 20.
Okay, I hear it.
Required.
I hear it. It's the interim order to
The
continue.
case is not like that. It is different.
Yes.
Only basis of the final form.
No, my lord. It is different, my lord.
But think of I'll quash it. Don't
My lord,
burden the case.
if I will read the statement,
Okay.
your lordship will,
Okay, let him be satisfied.
my lord, great.
Yes. 78. I know. Yes.
78. In this case,
Yes.
on the last occasion, in fact, he was directed for mediation with on records 10/11/2024, but not 10/12/2024.
Happened? Anything happened?
My lord, mediation has.
And in person to that, we attended the mediation on 10th as well as 17th, and that is held. Report will come, my lord.
Failed, your lordship.
Mediation, it is stated at the bar that the matter was subjected to mediation. However, the same was unsuccessful. However, the mediation report has not yet been received by this court. Leaves the matter or interim order to continue.
79 will fix, otherwise.
Date. In all matter, date.
My lord, your lordship will recollect, your lordship has already heard that matter. 1 lakh, we had offered them 3 crores, but they are wanting 4 crores.
He is making offer right now. Will you ready to take that amount? I'll ready.
Your lordship may decide, my lord, your lordship can.
He's offering, don't confuse now. He's offering straight away 3 crores. Take it and finish it up.
Within 1 month, let them pay.
My lord,
He has to arrange money.
But we
1 month.
not agreeable to any.
my lord, yes.
Call. Finish, take the money. It's 138 in any case. You fight it out for years together, you may not get.
Best credit loan, 14.2.
Just don't bring anything and then again add to confusion. He is paying 3 crores. Is your client ready tomorrow? To seek instruction, come tomorrow?
Yes.
I'll record it and forget about anything.
After lunch, my lord.
Tomorrow after lunch, 2 o'clock. 2 o'clock, come with the info. You seek instruction, your client may misunderstand you.
No, I have talked today.
Where are they?
Today to my client.
How much time will you take to give 3 crores?
My lord, 3 months. I will have to sell off my property. So 3 months.
To the bona fide, how much you will deposit right now?
My lord, let me take that instructions and I'll get my.
Come tomorrow with this offer. Don't alter the offer.
Yes, I will take that.
3 crores with 3 months.
Exact
So bona fide, at least 1 crore deposit.
Take it.
Let me
take that
You
instruction.
come and finish it up.
Grateful.
This case will be finished.
Grateful, your lordship. I'll.
Don't add anything. You are very dangerously. Don't do.
2.90.
It's all right. Next 3 crores, 3 months. To show bona fide, 1 crore deposit.
Acha, see, Tine Gotti jo कहले 2.9 crores, that was failed. I'm sorry, I stand corrected.
Don't try to be wiser now. Huh?
Yes.
This is the offer.
That will come tomorrow. No, my lord, I would have said it otherwise.
Tomorrow, 2 o'clock. 2 o'clock.
79. Continue with this period.
and fixed it for final disposal in January. Stay was already continued. But the predecessor has inclined negative, which is why I challenged in the Supreme Court. And the Supreme Court has continued it for about 6 weeks and said, go back to the High Court and it will continue. That application is already there. This similar the order of the Supreme Court, stay was granted. And ultimately, 20th of August 2024.
Where is that order? Yes, I got that order.
There is the order.
Yes.
So the stay did continue for about 6 weeks. And in view of that law, High Court Bar Association allowed.
You put it for 6 weeks. From today?
6 weeks. Well, the application was filed within time, but it has come today.
Shall continue for a period of 6 weeks.
And thereafter make a prayer before High Court. He's making a prayer.
6 weeks have already gone, Miller.
Making a prayer.
28-24. Order, Miller. 6 weeks from there.
No, but the same time the Supreme Court says that to go and make a prayer to, before High Court.
Miller.
The same time it says.
Miller.
So, without going into anything, you have to respect that order and extend it.
Miller.
Yes. This SLP was filed against what?
Against my order of 28th of September, where the first order
3237.
Yeah.
3237.
In 3237.
In the same.
Yes.
The order is 28/9/2022. Yes. But what was the order there?
Order was refusing to continue with the stay order that was granted.
The coordinate bench of this court by the order dated 28/9/2022 refused to stay the proceeding.
Yes.
Refused to stay the proceeding arising out of city case number 4 of 2050 pending before the court of designated court OPID Cuttack. Against the said judgment, the petitioner preferred and specially petition being SLP civil criminal number 9695 of 2022. The Honorable Supreme Court disposed of the specially petition by the order dated 20th 2024 inter alia stating as under reproduction. Mr. Tripathi, learned counsel for the petitioner, submits that the Honorable Supreme Court not only extended the interim order for 6 weeks, but also requested but also granted liberty to the petitioner to make request before the High Court for extension of the interim order. On the strength of the said order of the Honorable Supreme Court, Mr. Tripathi insists for an interim order. Regarding head to the aforementioned, I'm inclined to extend the interim order as passed by the Honorable Supreme Court by the order dated on 20th August 2024 till next date of hearing, leaves the matter for final disposal on give a date. December 20th December, 19th December, 19th December. Till then, this interim order shall continue. It is made clear that no adjournment shall be granted on the next date of hearing.
To 2 line I'm submitting, my lord.
Yes.
Your case, my lord, at the time of framing charge or time of cognizance, he has not challenged, my lord. At the time of flag end of the trial, my lord, when evidence of the IO is going on, thereafter they can file this application.
Oh, but that's right. But when this court declined to give interim order, pass some order.
No.
He went to Supreme Court. Supreme Court says that no, interim order should continue for 6 months, 6 weeks. Thereafter, he will request into the High Court, and then we have to extend it.
Yes, sir.
He may not have anything on merit. He is taking advantage of the time. Otherwise, I would have heard it at length. Okay, it's all right. Yes. He took right advantage of the calm of this storm.
Interpret saying something.
Yes.
Money has been taken from us, but they have not given till now.
Which one?
I am the intervener in this case, my lord. 5,50,000 I have taken.
Which matter you are talking about, sir?
In my 79. That's it.
I'll hear you.
Oh, yes, yes.
I'll hear you. Have you moved an application?
Yes, yes.
Application is allowed.
Intervention allowed, it is also.
You want to file any reply? Or any?
I have also given reply, affidavit, everything. So that's why it will be hard.
I'll hear you.
Yes, yes, ma'am.
Record the name of sir as your interview. Yes. Yes, 80.
May I please, Your Lordship? Lordship, the allegations are predominantly, Lordship, civil in nature. Lordship, which has already been compromised. Lordship, affidavit is already been filed, my lord, flag B. That's by the OP party number 2, my lord.
Are they present?
He is present, my lord, OP2. In person, he is present, my lord.
And what about the accused?
The accused is not present, my lord. He is
well,
Lordship, he is the cabinet minister. He had some meetings, so like Lordship wants I can ask him to present, my lord. It has been compromised.
He has to appear.
There is an agreement which has been annexed to it.
No, online let him appear.
Yes, my lord. Tomorrow? Yes, my lord. Tomorrow? Yes, my lord.
Yes,
at 2 p.m., my lord?
2 p.m.
If may I pray?
Yes.
Great, my lord.
Yes. Oh, no, what are the allegations?
Offences, my lord, 419, 420, 460 and 506, my lord.
Who is the complainant?
Complainant is OP2, my lord. He is present.
He is also a politician.
No, my lord. There was a business transaction between both the parties, my lord, with respect to sale of land. That amount has already been paid along with interest.
I am just asking whether he voluntarily is doing or because of some other reason.
So, lordship, he is present person, my lord.
Because the accused is a sitting minister, so the
lordship, he had just been
call him.
The affidavit was filed, my lord.
Coming. Is he under pressure? Ask him. ଆପଣ ନିଜ ଇଚ୍ଛାରେ କରିବାକୁ ଚାହୁଁଛନ୍ତି ନା ଆଉ କଣ ପ୍ରେସର ଅଛି ଆପଣଙ୍କ ଉପରେ? କିଛି ଡରିବାର ନାହିଁ, କୁହନ୍ତୁ। ସିଓର ପଇସା ପାଇଲେ ବ୍ୟାଙ୍କ ଥ୍ରୁରୁ ପାଇଲେ ନା କ୍ୟାଶ ଡିଲିଂ ହେଲା? ବ୍ୟାଙ୍କରୁ bank particular likhଛନ୍ତି ଆପଣ affidavit ରେ?
Lordship, that compromise it also that was entered in 2018, even before the petitioner was about a politician, my lord. 2018, that's as you mentioned, my lord.
Yes, I want to know whether there is any pressure or something. Nothing.
My lord, please.
Nothing else.
Yes, my lord, please.
Yes, at 2 o'clock tomorrow.
Grateful, my lord.
Then let us hear mentioning one.
Entry mode to continue, my lord.
Entry mode to continue. Till tomorrow, what will happen? Till 2 o'clock. Yes.
Grateful, my lord.
I think any urgent mentioning.
Matrimonial dispute, divorce is allowed.
She is not coming.
No, she does not want to proceed.
Evidence affidavit already filed in simply proceeding to file.
Matrimonial dispute, she has already married. I am necessary.
Yes, yes, sir.
Yes. Yes, sir. The rest of the matter, if is so very urgent, let it be tomorrow. If there is entry matter, I will extend it. 1 minute. Let us go serious.
7, my lord.
Let it be there.
Yes, my difficulty is that every day that the officer, superannuated officer, educated officer, it's in my home every day, my lord. And I come this time only to manager.
Not for this case, sir. No. He is retired. He has no job. Therefore, he is time passing. He
comes here. I am not keeping too well also.
And you are a good host. That might be another reason. So don't worry, I'll take it up. Let it be there.
Yes, let it be there.
Tomorrow also I may get some time.
Yes, sir.
Today I wasted about half an hour. Otherwise, I think I would have reached.
Because my lord, I fixed this matter at 3 o'clock thrice.
Timing has no sanctity, you know. If these kind of things happen, then
only one point is there. My lord, let them answer. They were supposed to. Now that he is available.
Nobody is there. That's
right. He had indicated yesterday that the case diary is available.
Then I'll take it up tomorrow. Then.
Yes, ma'am.
Tomorrow, let it be 3:30 then.
Yes, ma'am. That's
3:30.
That's fine. I was only praying for 82.
No, no, sir, tomorrow is a Friday. Tomorrow is a Friday. It will be tough. Let it be next week only.
All right.
Tomorrow may not
Next week,
happen.
may fix it on Wednesday.
Wednesday?
Yes.
Okay, Wednesday.
25th, 26th, I'll be.
Yes, Wednesday then.
Yes, sir.
Wednesday. Okay.
That 3:30.
82,
3:30, what?
3:30. Let it be 3:30.
82, I was only praying.
82.
82, I am protected by your lordship's order. Your lordship, if you're convenient, can be taken up Wednesday next spring.
I don't know. Wednesday. Acha, notice is sufficient.
What is this?
Your
lordship have been
somebody
got everything. I have been protected also. So my 138 proceeding, he has filed one case before the police and all this thing. Your lordship please to take it next
order
week,
to continue.
very small.
Service awaited. Service on the opposite party number 2 is awaited.
Right,
sufficient. Service completed, but nobody entered appearance. In the interest of justice, urgent to so and so, and interim order to continue. Let it be on somewhere
First week of December.
First week of December.
Your lordship may fix it to 4th of December and we apply. If your lordship is convenient.
Let it be 9th. That's what he says.
Item number
Interim order to continue.
Item number 83 tomorrow.
Tomorrow, we both are present.
Settlement matter.
No, no, this is a matter relating to 38-year prosecution going on for provident for. No payments have been made.
They have to seek instruction. Okay.
Tomorrow.
My lord, I'm mentioning item 97, my lords. My lords, this is a quashing petition against a criminal complaint. My lord, the respondent has approached us for a... My lord, we are just trying to fill the matter. If my lord may keep it 3 to 4 weeks.
Failed to produce the filed
That we can arrive
account
at
and
settlement.
made a DD of settlement in favor of opposite party too. Please the variant.
Very happy.
And your lordship stands partition mediation, but the mediation failed since the opposite party number 2 did not approve many times.
Why have you not appeared?
I'm appeared.
No,
No, several times. One time I am not earlier that occasion I had mediation center and called to the father of the opposite party number 2. That's the father of the opposite party number.
You are not interested to settle the dispute.
So mediation report is there.
Mediation failed. What report? Only unsuccessful.
Your lordship will
I'll hear it. I'll.
10,000 in favor of opposite party too.
Item number?
86.
86. Pursuant to the order dated 28/2024. 28/2024. The counsel for the petitioner has handed over a draft of rupees.
Yes.
Draft particular draft number so and so. To the counsel for the petitioner. Release the matter.
Item
Entry mode to continue. Yes.
My lord, item number 106. Item number 106.
Yes.
Sir, I am appearing for the opposite party number 1.
What do you want?
Sir, in my lord, in the interim application filed with the CRLMC, the petitioner, that is husband, stated that
what do you want? You tell me. Don't argue at this time.
They have taken a order before issuing the summon, and after that order, neither the family court nor the SDGM means kind to entertain the application.
Want to argue the entire matter? What do you want? You tell me. What do you want?
106 is for list.
You want to tell that interim order is taken by making wrong statements?
Yes, sir.
That's what you want.
It's a first
Let me say that. Why are you going here and there?
First hour is
No, but when have you given the date? See, he says that the interim order is taken by misleading. That's what he says. Try to give a little early date. He will give, he preponed the date. There was somebody mentioned and got the date. And that date you intimate to the other council, other seconds. Okay.
My lord, weekly item 132.
Weekly don't mention. Don't mention.
Given for the.
Weekly don't.
Telling of them.
I'm not able to complete the miscellaneous board, what to do?
Item eight.
Tax given the framing of charge on 25th Monday, my lord. If it is heard tomorrow or else one adjustment.
After charge is framed, you have remedies, you know.
Remedy, but.
New application are entertained if you have a good case. Yes, Mr. Mishra.
87, your lordship remembers that acquittal where your lordship was prima facie considering for quashing because there is nothing to survive. So that matter. The lordship state the NW and.
What do you want?
If this may be taken up, if possible, my lord.
It will be taken up. See, the matter which I could not take today, those matter will be adjusted in the coming 2-3 days. 2-3 days and
There, my lord.
he'll try and adjust because see, many matters are listed, is not able to take up the matter what is used. You want to say something?
Again?
You want to have some?
8 घंटा कालिक ରହିଗଲା ତ ମୋର କିଛି କହିବାର ନାହିଁ ଆପଣ ଉଠିବେ ତ ମୁଁ ଆଉ ଯାଉନି।
Thank you.
Lord, item 9. Lord.
88. Whoever wants an adjournment, tell him, he will give the date.
The interim order was extended on the last occasion, but it was not reflected in the order.
84.
84 item. Interim order was that if I have any adjournment. That
Okay. That arrangement is extended 84.
Lord, item 90.
Item number 105.
Yes, sir.
If forbid, my lord, can you take care of tomorrow?
I already told that the matter which I could not I'll take up those matters.
My lords, item 90. Lords, item 90.